an idea to prank.
No, he goes, what's that, Jeremiah Johnson on me overnight?
Gotta put this out. Oh, put this rule. Some plants. Little trees to hang around.
I feel like us.
So I'll do my best. Elsie, can you hear me?
Yeah, I can.
Thank you. Hello, everyone. I'd like to call the December 5th, 2023 meeting of the Marine Resources Commission to order. Please stand for the Pledge of Allegiance by Board Member Ransom, followed by invocation by Board Member Irvin. I pledge allegiance to the flag of the United States of America, and to the republic for which stands one nation, under God, indivisible, with liberty and justice for all.
Let us pray. Thank you, Lord, for this day to gather here at Virginia Marine Resource Commission. Allow us the wisdom and knowledge to debate these Marine Resource Commission issues and fairly and equitably decide decisions in the interest of the marine resource. Amen.
Amen. Thank you. Thank you. Welcome, everyone. Welcome back to Fort Moreau. It's good to be back home. It's good to see everyone. We'll first get moving. I know there's a approval of the agenda. I know there's going to be some amendments or corrections to the agenda. Randy, you have some changes to the agenda you would like to make?
Good morning, everyone. At the request of the applicant, we'd like to remove item 5, Brian Twitty, from the agenda. We'll bring it back to you at a later date. On the page 2 agenda, item 2E, Columbia Gas Transmission, we now have received a number of protests. It was advertised both for subtitle and wetlands. We're the default wetlands authority for Chesapeake, so we're required to hold a hearing. So we'd like to move item 2E, if it's okay with where we just removed item 5.
So,
We would like to hear it before the John Eady case, if that's okay.
okay, so move 2E in place of where.
In place of item 5 and remove item 5 from the agenda. That would be my request, sir.
Is there any other amendments, or is that it?
That's all I have.
That being said, we have a staff recommendation to make a modification to the agenda. Do I have any?
Motion to approve.
Motion to approve from Mr. Erskine, a second from Mr. Bransom. Any further discussion on that? That being said, all those in favor of the change say aye. Aye. All those opposed? Thank you. Thank you, Randy. All right, moving on. The minutes. Are there any corrections, deletions, or changes from the commission members or staff for the October 24th, 2023 commission meeting minutes? Any corrections? That being said,
Motion to approve as submitted.
got a motion to approve from
Second.
Mr. Erskine. Do I have a second?
Second.
Second, Mr. Headley. All those in favor say aye.
Aye.
All those opposed?
Abstain.
Ms. Less abstained. Thank you. Please let the record reflect that Associate Member Ms. Kellum and Ms. Edwards is not present today. But we do have a quorum. All right, next we'll swear in VMRC staff and VIM staff that will be speaking or presenting testimony during the meeting. You swear to tell the whole truth, nothing but the truth, so help you God. Thank you. All right, Randy, I think we're on you, Randy.
Mr. Green, members of the commission, good morning. These are page 2 items. We have removed, as we discussed, item 2E. I'm going to go over items 2A, B, C, D, and F for you. Item 2A, the Norfolk Office of Resilience is requesting authorization to install a 24-inch diameter water line via horizontal directional drill beneath the eastern branch of Elizabeth River between Harbor Park and South Main Street in Norfolk. This is in item 2B, or to accommodate the Norfolk flood wall that is eventually going to be constructed in that area, so they need to relocate these utilities in advance of that project. The line will be installed approximately 66 feet below the natural riverbed with no in-stream construction impacts. We are recommending approval with the inclusion of the frac out contingency plan submitted with the application. Item 2B, Verizon Virginia LLC is requesting authorization to install a 16-inch HDPE communication line 40 feet beneath the riverbed of the eastern branch of the Elizabeth River horizontal directional drill between Harbor Park and South Main Street in Norfolk. The line is needed to maintain current utility service in anticipation of the new Norfolk seawall in this location. We recommend approval with a royalty in the amount of $2,370 for the encroachment beneath 790 linear feet of state bottom at the rate of $3 a linear foot. And also that will be contingent on the frac out plan as well that they submitted. Item 2C, Prince George County is requesting authorization to install a 24-inch water main beneath 411 feet of the Appomattox River, horizontal directional drill near the Route 144 bridge in Prince George and Chesterfield counties. We recommend approval with the adherence to the frac out plan. Item 2D, James City County Service Authority is requesting authorization to replace an existing water main with a new 16-inch line beneath 595 linear feet of College Creek, and it will be attached to the Route 199 bridge in James City County. Item 2F. Item 2F, you are serving as the default wetlands board for Chesterfield County. Northern Neck Construction is requesting authorization to install 214 linear feet of riprap revetment landward of Meanlow Water, but right up against the bank adjacent to James River at 12100 Ganesh Lane in Chesterfield County. That project does require a wetlands permit. And if I were to show you the pictures of the house and the bank between the house and the bank of the James River, you would understand why they're doing it. Their house is being threatened by the bank erosion. Those are all the items I have, sir.
Any questions for Randy from the commission?
Thank you.
Is the applicant or representative of the applicants for any of these projects here wish to speak? Any speakers in support? Or any speakers in opposition for any of these projects wish to speak? That being said, matters before the commission.
Make a motion to approve page 2 items.
I got a motion to approve these 2 items. Do I have a second from Mr. Headley? I got a second from Mr. Bransom. Any further discussion? All those in favor say aye. Aye. All those opposed? Motion carries. Thank you. Thank you, Randy. All right, no consent. I'm gonna guess, Kelsey, we don't have a need for closed meeting for consultation today, do we?
No, sir.
All right, moving right on. So we're on to the new item number 5, which is Columbia Gas. I believe we have one member that needs to recuse.
This time I'm going to recuse myself. Thank you.
Let the record reflect that Mr. Minor has recused himself.
Good morning.
Good morning, ma'am.
So this morning, I'll be presenting VMRC application 230100. Columbia Gas Transmission is requesting authorization to replace approximately 50 miles of existing 12-inch diameter gas pipeline with a 24-inch diameter steel gas pipeline using the horizontal directional drill method, crossing 7 jurisdictional waterways in Isle of Wight County, Suffolk, Chesapeake, and to impact tidal wetlands for the widening of an access road associated with the pipeline replacement in the city of Chesapeake. This project, as Randy mentioned, requires a VMRC wetlands permit since VMRC is the default wetlands board in the city of Chesapeake, and will also require subaqueous permit for the 7 jurisdictional crossings. The cost of the subaqueous components exceeds $500,000, and the project is also heavily protested. Here's an aerial of the 7 jurisdictional subaqueous crossings spanning from Isle of Wight southeast to Chesapeake. Here's the plan view of the project route, again, where you can see it spans multiple counties. All of the jurisdictional crossings will be conducted using the HDD method. No in-stream work is proposed for these crossings. And next, I'll run through each crossing individually. So starting in Isle of Wight, the first crossing will span a 49-foot section of Clupahunk Swamp in Isle of Wight. The next crossing is also Isle of Wight. It spans a 380-foot section of the Blackwater River. The third crossing in Isle of Wight is a 37-foot section of Villeneuve Swamp. The next crossing is in Suffolk. It spans the Western Branch Reservoir, and since the reservoir is man-made, only the historic stream channel is jurisdictional to VMRC, and this is a 145-foot crossing. Here's a closer view of the historic stream channel that's jurisdictional to this board. The next crossing is in Suffolk, and this is a 478-foot section of the Nansemond River. The last two crossings are in Chesapeake. This one spans a 1,054-foot section of the Southern Branch Elizabeth River. And the last crossing spans a 126-foot section of the Elizabeth. This is the location, circled in red, of the tidal wetland impacts in the city of Chesapeake. This site is adjacent to a man-made canal and is situated next to the Columbia Gas Transmission Facility. The impacts to tidal wetlands are associated with the expansion of an existing access road, and you can see those, let's see, in red here. They're associated with the expansion of the access road that is already there and the new pipeline tie-in facility. They're going to be replacing some what they call PCR boxes. The proposed impacts total 3,049 square feet of permanent vegetated tidal wetland impacts and a total of approximately 78,000 square feet of temporary wetland impacts for the potential use of timber matting and temporary staging areas. And this is a ground shot of what was just shown on the plan view. The access road is here. So this project is protested. We have, as of 9 a.m. this morning, we've received 164 protests in total. The primary concerns include the continued reliance on fossil fuels, emissions contributing to climate change, the loss of habitat, negative impacts to endangered species, public health concerns, and the proximity of the pipeline to homes, schools, and businesses, and impacts to underserved communities and other environmental justice issues. In sum, after evaluating the merits of the project and considering all the factors contained in 28.2.1200 and 28.2.1302 in the Code of Virginia, staff recommends approval of the project as proposed with a royalty in the amount of $6,810 for the encroachment under 2,270 linear feet of state bottom at the standard rate of $3 per linear foot, and the permit condition that the applicant agrees to follow the frac out monitoring plan, frac out monitoring and response plan provided in the application, as well as the purchase of wetland credits at a 1-to-1 ratio from a mitigation bank for the permanent impacts proposed. I am available for any questions that you may have, and I believe an agent for the project is present.
Is there any questions, Mr. Branson?
Yes, could you go back to the map where it crosses the Elizabeth River? It was the last one, that one. Where exactly is that in Elizabeth River? I can't really.
This one is by the Chesapeake Energy Center.
Okay. And the next picture, if you forward one slide, that one, okay.
And this is that canal here.
Okay, I see Gilmerton Bridge.
South Mary
Right,
Military,
okay,
yeah.
I understand where it is now, thanks. Okay.
Any more questions? Representative?
I have a question, Commissioner.
Yes, sir, Mr. Ham.
What's the bond amount on this project?
So there is no bond, but we do have a royalty amount for the subaqueous crossings, which is, it was $6,810. And the wetland credits are, well, that's not directly paid to us, but we are ensuring that they pay for those through the wetland bank, New Mill Creek.
Yeah, so I don't have a problem with the project and the need for such a project, but if things don't go well and if things are not restored correctly, what's the default plan? What's the enforceability?
Any violation of any permit condition for either of these permits would be a violation of this board's jurisdiction, and we would pursue that with our standard enforcement procedures.
Like a fine?
It can involve a fine. It depends on what the violation entails.
Yeah. I mean, I wanted, I'm curious to know how much, what would be the limits on such a fine if things didn't go well?
I think the bond question too is probably, and just when if the agent is here or the applicant maybe can answer that probably better than staff can, whether that they bond it, so. But, yes, sir, Mr. Branson.
And if I could clarify, this is a replacement of an existing pipeline, correct?
Correct.
Inch going to 24 inches, that's an active pipeline. Is it being replaced because of increased demand, or is it because of deterioration?
It is being replaced because of increased demand on energy, and it has exceeded its lifespan. So
So there's risk if you don't go through with an increase in this pipe, replace the pipeline.
from what I
There's risk
understand,
of
yes.
environmental, that I'm reading a lot of the protestant letters here, that there's a lot of concern about, environmental impact, not so much from global warming, but from any kind of, leakage or things like that.
Yeah, that's correct. And just to clarify, at the 7 jurisdictional crossings, they will be cutting the old pipeline in the uplands, capping it, and there will be no in-stream work there. They will be
Right, it's
putting-
horizontal directional drilling.
Correct, for the new,
And
yeah.
they remove the old pipeline, they remove the old pipeline.
So for our 7 jurisdictional crossings, they will not be removing that section of pipe.
Boring next to it or something.
Yeah, they'll be doing HDD next to it. They will be cutting and capping the old
I would
pipeline.
imagine removing that pipeline over our jurisdictional crossings would cause a whole lot more disruption of the river and
Correct.
be a lot more environmental impact.
Correct. There are no in-stream impacts for those 7 crossings.
Right, thank you.
Any more questions? Thank you.
Thank you.
Is the applicant or a representative for the applicant here, present and wish to speak? Please come forward. Raise your right hand. You swear to tell the whole truth and nothing but the truth, so help you God?
I do.
Can you state your name for the record at the microphone?
My name is Melissa Detley. I'm the environmental project manager for this project. The only thing I wanted to address, just to assist in what I heard from the conversation before, is that we do have regulatory oversight from the Federal Energy Regulatory Commission for the way that we commit to adhere to all of our permit conditions. We're held to monitoring for up to 5 years to ensure that everything is put back accurately. We also have those same requirements of the Corps of Engineers. So there's several levels of oversight for us, returning these resources back after, after the impacts.
So, any questions? Mr. Hand, Mr. Erskine, go ahead.
Good morning. So you have a history of doing this and a record of this kind of work?
Yes, we do.
And what's that track record like as far as, doing this work? Are there any issues that may arise, whether environmentally or otherwise?
And when you say doing this work, I just want to make sure I'm addressing, would it be the horizontal directional
Similar
drill
projects,
or
yeah.
pipeline replacement?
Yep,
Yeah.
both.
I mean, the company, this pipe has been in the ground maybe since the 50s. I've been working in the industry for 22 years. I know that any project I've ever had that's had like horizontal directional drill, wetland construction, things like that. I don't know that I could give you percentages, but I've never witnessed or been a part of a project that had any type of horizontal directional drill failure. They ensure that they monitor 24 hours while this activity is ongoing. They measure the pressure, how much fluid is coming back, anything like that, so that they can stop. And I've never experienced on any of the projects that I've worked in my 22 years, a complete failure of a HDD of a resource.
Okay. Thank you.
Any more questions? Thank you, ma'am. Is there anyone else here that wishes to speak in support of this project? Is there anyone here that wishes to speak in opposition to this project? Please come forward. Raise your right hand. You swear to tell the whole truth, nothing but the truth, so help you God?
Yes, sir.
Please state your name for the record and the microphone.
My name is Jeff Staples.
Proceed.
Okay. First of all, I'd like to address what is seemingly the need for this. I live in this immediate area, and I can tell you that the need has not been exceeded of the 12-inch pipe now. Almost daily, when I drive by, I see at the Chesapeake Energy Center flaring going on, which is usually because of increased pressure in the pipeline that they need to vent. Also, the existing pipeline has served us well, and I think it can continue to serve us well until we achieve the next step in transition to renewables. Another thing is, having lived there, fished there, and been around a long time, I can tell you that that area right there has been decimated by industrial pollution. There's tire dumps, there's creosote poisoning, there's coal ash. Matter of fact, did a survey of arsenic in that immediate area just several years ago, and it was contaminated. One crab had like 80 times the amount of arsenic in it that it would take to kill a person. So we've got all that going on, and this further disturbance could wreak havoc on the Elizabeth River right there. It's just something that we do not need. The existing pipeline can carry us through, and we should be happy with that. It's a very delicate ecosystem that's starting to come back, and I would hate to see progress made be crushed by that. So please deny this application. Thank you.
Any questions for the speaker from the commission? Thank you, sir. Okay. Is there anyone else in the audience that wishes to speak in opposition to this project? Anyone else? Raise your right hand. You swear to tell the whole truth, nothing but the truth, so help you God?
Yes, sir.
Please state your name for the record.
Frida Cathcart. I'm from Roanoke, Virginia. I represent Roanoke on the Soil and Water Conservation Board. My background's in insurance. I'm an FLMI, and I'm an energy investor. One of my investments is in Dominion Energy. I was the shareholder that carried the resolution last year asking for a report on natural gas stranded assets. And I had to defend that resolution at the SEC against Dominion's top partner with McGuire Woods that was representing them. And I won. And it went before the body of Dominion Energy, and it won by over 80%, which is basically unheard of that shareholder resolutions ever pass. But this is the state that we're in with natural gas and stranded assets, and the ripple effect that it has through our economy as well as our environment, and how they intersect with each other. And in the corporate level, especially the industry level, we are well aware of the consequences of the liability and the risk of continuing to allow an industry to flagrantly accelerate extreme weather events. Nobody likes extreme weather. It's bad for everybody. The person whose home is flooded to the businesses that are damaged because of whether it's the wildfires or the flooding. And this particular area is the second most vulnerable in the nation. And this area is really important when it comes to our national security. And when it comes to building natural gas pipelines, there is a governmental incentive for companies to do that because companies like Columbia Gas can make more return on their investment by building an infrastructure project than they can by providing the utilities services. Like more than double. We're talking like 12 to 15% return on investment. It's for corporate greed. It's not to serve our communities. And it's disgusting. And there is currently in Congress a legislative fix to stop that, to stop FERC from approving these projects because of the harm that they're doing to our economy and to the environment. That is pending. But right now, you have the opportunity to deny this permit and protect this fragile environment of this area. You would be protecting the Norfolk region, the whole Tidewater region, from the harmful effects of extreme weather. And also, you would be protecting the investors of Columbia Gas, because this pipeline's not going to go anywhere. Just like the Atlantic Coast Pipeline, and if you've heard of the Mountain Valley Pipeline that I've been immersed in since 2014, they just announced Friday that the major partner is looking to sell because they know it's a boondoggle. They know it's an albatross.
Ma'am, your time is up.
If I can just wrap up, the Tennessee pipeline that serves our area has been in service since 1943, and nobody's talking about replacing that. So it's not necessary. Thank you for your time.
Any questions for the speaker? Thank you. Is anyone else in the audience that wishes to speak in opposition to this? Remember, guys, it's 3 minutes. 3 minutes you had to speak. Anyone else? That being said, matters before the commission. Mr. Erskine?
I appreciate the testimony and that this was taken from a page 2 item, maybe that didn't have, the opposition previously. And thank the opponents come out and the applicant as well, maybe on short notice, come out and discuss this. I see this as an issue where it's an existing pipeline that's been there for a number of years, decades in fact, and I appreciate the concern, but if we haven't seen concerns or environmental issues or otherwise with the existing pipeline, I don't think the applicant would be going to the extent to replace something larger in that investment without the need and demand. So I'd make a motion to approve Columbia Gas applicant as submitted.
Motion to approve from Mr. Erskine.
I'll second.
I have a second from Mr. Bransom. Is there any further discussion from the commission? A motion to approve from Mr. Erskine, a second from Mr. Bransom. Any further discussion? That being said, all those in favor say aye.
Aye.
All those opposed? Got one opposed. It's 4-1 carries. Ms. Lusk opposed. Thank you. Thank you all. Shanna, can you get Mr. Minor for me, please? Thank you. All right, moving on. So, Mr. Madden, I guess you're up.
Mr. Commissioner, associate members, good morning.
Good morning, sir.
We'll turn our attention to Stafford County. The matter of Mr. John Eddy, excuse me. Let me get this going. Hello. Yeah. Slideshow. Okay.
Then hit first slide, right there.
Thanks, Randy. Thank you, sir. Mr. John Eddy requests after-the-fact authorization to retain a 213 linear foot timber replacement bulkhead with associated backfill constructed 14 inches channelward of an existing bulkhead over state-owned submerged lands adjacent to his property situated along Potomac Creek at 18 Man Drive in Stafford County. The location of the property is, you see the red balloon. It's at the confluence of Potomac Creek and the Potomac River. Fredericksburg is off the slide to the southwest. On January 18th, 2023, Commission staff received an email and images from the Stafford County Wetland Board describing an undocumented replacement bulkhead under construction by Mr. Eddy. Mr. Eddy was immediately notified, and a site visit was arranged on February 6th, 2023. On February 6th, staff met with Mr. Eddy and their engineer agent, Mr. Jim Beck. I'd like to take a sidebar here for a moment and mention that Mr. Beck was brought into the project after the bulkhead was constructed. So his involvement is after the fact here. And as a matter of fact, Mr. Beck produced these drawings and the application, the after-the-fact application that was submitted subsequent to the visit. At that time, staff confirmed that the 213 linear foot replacement bulkhead was constructed 14 inches channelward of the existing bulkhead. You'll see photographic evidence in a moment. This was done without the required VMRC permit because it extends beyond mean low water. The new bulkhead appeared to have been bolted directly to the older failing bulkhead without any evidence of the installation of dead man anchors. During the site visit, staff learned from Mr. Eddy and that Mr. Brad Martin, representing Shoreline Services and Design LLC, constructed the replacement bulkhead. Mr. Eddy advised that he had previously signed a contract with Shoreline Design on November 14th, 2021, and that's in your packet. Here's the design. This is what you see if you were actually going out on the property. And there's the Eddy's home, and along the shoreline, you'll see it in blue. You'll see that a new bulkhead has been attached to the older structure. Let me go give you a kind of a look here. If you look on the lower left-hand side, you'll see that the remnants of the old bulkhead, and you'll see also that some piles have been driven, and as far as I can tell, and Mr. Beck was with me at the time, it appeared that the piles and the bulkhead are bolted directly to the old structure. Here's another view. This is the picture that was actually submitted by the Wetlands Board member. His shadow is on the lower right. That was Jim Fiorello. And January 18th, 2023 at 9:12, he took this photograph showing work underway on the bulkhead. After the site visit, and let's just show you another picture. This is a picture I took at the site visit. So that's the new bulkhead. We're looking upstream. Now we're looking downstream. There's the gap right there. You see 14 inches offset from the old. You see the old bulkhead nearer to my thumb, and the new one's outboard of it. After the site visit was completed, a sworn complaint notice to comply was compiled. The notice to comply, which was served by Marine Police to Mr. Eddy and Mr. Martin in September 2023, directed Mr. Eddy to remove the unauthorized bulkhead or submit a completed JPA application for review and consideration by the Commission at a future date. The notice was also directed both Mr. Eady and Mr. Martin to appear before the commission once scheduled to explain why the bulkhead was constructed in the absence of a VMRC permit. As I mentioned before, we received a application on September 11th, 2023, and that was the drawings that you saw a moment ago. What they're requesting authorization, of course, is to keep the bulkhead and also install proper tiebacks, to plumb a leaning section about 20 feet long, install drain pipes, and backfill the replacement bulkhead with 57 stone. And Mr. Beck can give you a lot more, some more construction details if you wish. Mr. Eady, from his first encounter with VMRC, has been very forthcoming with information and very cooperative. Staff believes that his lack of familiarity with the permitting process caused him to rely heavily on the input from Mr. Martin, his contractor. With respect to Mr. Martin, however, staff believes that there is no excuse for an experienced marine contractor to undertake work in the Commonwealth without first filing the required application and obtaining the necessary local and state authorizations. Mr. Martin has a lengthy history of unauthorized construction with VMRC and most recently appeared before the Commission on April 25th, 2023, to explain his role in the unauthorized construction of a dual-slip boathouse and pier in Prince William County. Members might recall that was the Emmons project, 2021-1951. In that case, Mr. Martin would not consent to the $9,000 civil charge assessed by the Commission in the case. Mr. Martin, in lieu of further enforcement action. This matter has been turned over to the Office of the Attorney General to pursue civil charges against him for the unauthorized construction not to exceed $25,000 by the appropriate court for each day of violation pursuant to Section 28.2, 1313A of the Code of Virginia. Mr. Martin was also assessed a $10,000 civil charge by the Fairfax County Wetland Board on October 12, 2023, for his role in constructing an unauthorized bulkhead in tidal wetlands along Massey Creek in Fairfax County. From a review of our files, Mr. Martin's role as the marine contractor was investigated by VMRC staff and the Commission for 5 additional past violations involving the unauthorized construction of bulkheads and riprap along shoreline in Stafford and King George counties in 2008 and 2010. The table below summarizes the collective unauthorized work Mr. Martin has been found to be responsible for or the subject of this current public hearing. Given that this is the second appearance by Mr. Martin before the Commission in less than a year, and in light of his repeat offender status, staff recommends that the Office of the Attorney General be directed to pursue civil penalties against Mr. Martin for his role involving the unauthorized construction of a bulkhead at 18 Men Drive in Stafford County pursuant to Section 28.2, 1213 of the Code of Virginia. Further, that the Office of the Attorney General additionally seeks civil penalties for his role in the unauthorized construction of a boathouse at the Emmons property, mentioned previously, in Prince William County, as directed by the Commission at its April 2023 meeting. As for Mr. Eady, in light of Mr. Eady's continued cooperation to date and reliance on Mr. Martin as his contractor, staff further recommends that the Commission approve the after-the-fact request to complete the construction and backfilling of the 214-foot replacement bulkhead. Such authorization should be conditioned on the assessment of a triple permit fee of $900 and triple royalties of $735 in lieu of further enforcement action. Mr. Eady, who is present today along with his wife, has agreed to the subjected triple permit fee. If you have any questions, of course, I'm available for anything you might have.
Any questions from the commission? Any questions?
Commissioner Hyde.
Mr. Branson?
Jeff, thank you. In addition to the VMRC permit, was there any other permits required, construction permits by Stafford County or anything like that?
Well, generally, the Stafford County gets pretty much involved in these sorts of things, but it was all beyond mean low water, so
Okay.
the county lacked authority.
Squarely within VMRC's jurisdiction?
Yes, sir.
No.
And based on the fact that what we could tell, what Jim and I could tell, there was no land disturbance along the bank,
You
therefore
didn't put
they
any
would have a
dead men's in,
disturbance
no
permit.
supporting structures for it?
Right.
I mean, no dead men, so which would be, I imagine, uplands.
Yes. Now, that's supposition on my part. It's not based on my having done any bore samples. It just appeared, as a matter of fact, it shows on that image there, the bolts go right into the bulkhead, old bulkhead. But that's just supposition on my part. I'm not a professional engineer, but Mr. Beck is.
Okay. I have some questions for him.
Any more questions?
Thank you so much.
Is the applicant or the representative of the applicant here wish to speak, please? Are you the attorney for the applicant?
I am not. I'm the engineer,
Okay, you
Jim
swear
Beck.
to- You swear to tell the whole truth, nothing but the truth, so help you God?
Yes, sir, I do.
Please state your name for the record.
Jim Beck. I'm the engineer for the applicant as well as the agent for this after-the-fact JPA.
Proceed.
With respect to the JPA that's before you, again, as been noted, it's an after-the-fact JPA. The bulkhead was basically reinforced, has a veneer on what was a failing bulkhead. As Mr. Madden stated, there are no tiebacks. There are some improvements that need to be made. There's a 25-foot section that needs to be plumbed a little bit. I think we can do that with duckbill tiebacks, and then the interstitial space between the existing and the new bulkhead needs to be filled with 57 stone. And that's essentially what we are requesting with this after-the-fact JPA.
Okay, Mr. Branson?
Thank you, Mr. Beck. The tiebacks, how far inward are they going to be installed? How far do you have to go to structurally support this?
It's not a tall bulkhead. I would imagine about 8 feet, and we could either do excavated tiebacks or duckbill type tiebacks that are just driven into the ground.
Will that require permitting from Stafford County?
It depends on the area. This would not be a wetlands disturbance.
Okay.
And I think the actual disturbance would be small enough that it would not require Stafford County permitting.
Okay.
Any more questions?
Well, I just had a couple follow-up, Commissioner. Did you review the drawings for the original bulkhead? I know you didn't design it, you designed the JPA.
And actually, in 2017, I did prepare drawings to replace the sheeting on the existing bulkhead. That project was permitted through Stafford County. It did not come before the commission because there was no disturbance to the bottomland. And a portion of that work was completed, I would say about 50.
I meant for the structural drawings for the
existing
failing,
wall?
the existing failing wall.
No. I can't imagine those drawings exist.
Okay, all right, thank you.
Any more questions, staff? So we apparently have two separate issues before us. We have the contractor that's built another project without a permit, and now we have which that will handle that second. But first, we have the after-the-fact issue here before us. So, thank you. I need to ask if there's any opposition for this project before we move on, but if there's no further questions for the speaker. Thank you.
Okay.
Is there anyone here to speak in opposition of this project, the after-the-fact permit for this project? That being said, matters before the commission. Mr. Erskine.
I'd make a motion to approve the after-the-fact permit.
A motion to approve the after-the-fact permit.
Second.
Have a second from Mr. Minor. Is there any further discussion? That being said, all those in favor say aye.
Aye.
All those opposed? Motion carries. Now on to Mr. Martin. Is Mr. Martin here or his representative? And,
Yes, sir. Good morning.
are you attorney for Mr. Martin?
Yes, sir.
I don't have to
Tyler
swear.
Roth on behalf of Mr. Martin.
Please state your name for the record, please.
My name is Tyler Roth, R-O-T-H.
Proceed.
Members of the commission, we certainly don't oppose the after-the-fact proposal or permit plan. We do, however, vehemently object to and oppose the characterizations of Mr. Martin's involvement as portrayed by previous speakers. It's false that Mr. Martin constructed the bulkhead, that he had any involvement in the design of the bulkhead or the implementation of it to the old bulkhead. Mr. Martin was not personally responsible in any kind of individual capacity with regard to this project whatsoever. At the time of contracting, Robin Harvey was the sole owner of Shoreline Service and Design. Ms. Harvey is the individual who signed the contract with Mr. Eady. I do have a copy of that contract. I'm not sure how the admission of exhibits work in this sort of proceeding, but I'm certainly happy to pass that up.
You can bring it forward, but it stays with us.
I think that's okay.
Okay.
If you'll indulge me for just a second. May I approach?
Approach, please. Thank you, sir.
A copy of the contract. The first signature on the last page of the contract is Ms. Harvey's signature. The other one is Mr. Eady's. And I'll continue whenever you all have had a chance to take a look.
Proceed. Proceed, sir.
There was no personal guarantee signed to this contract by Mr. Martin. Again, Mr. Martin's signature doesn't appear on that contract whatsoever. In fact, Mr. Martin didn't even visit the job site. I have a number of affidavits from Shoreline Service employees who did visit the job site, who were at the job site every single day with Ms. Harvey, and who affirm that they worked at her direction, at her behest, and only her direction and behest. May I approach with those affidavits?
You may. You can hand them to Officer Custer.
Yes, sir. I believe I have 5 here.
Commissioner, I have a question. Counselor, is this Stafford County or Westmoreland County?
I believe the affidavits were notarized in Westmoreland County, but my understanding is they pertain to the project that's at issue today. That can probably be confirmed by the notary stamp on the back. I didn't take the closest look at that, but that would be my guess. And I believe that's because Shoreline is incorporated in Westmoreland. Their principal office is in Westmoreland County. I just have a few more comments whenever I'm permitted to proceed.
You can proceed. They're going to have to look this over, but you can talk while they're looking it over.
Yes, sir. So again, those affidavits reflect that the employees who worked on this project worked at the behest of Ms. Harvey. Ms. Harvey was fully and totally in charge of this project, and that was on a daily basis, as I think is explicitly mentioned in those affidavits. And Ms. Harvey is the one who directed all of the work for the project. Mr. Martin did not direct, did not perform any work whatsoever related to this particular project. Ms. Harvey and not Mr. Martin is the qualified individual of Shoreline Service and Design. Mr. Martin is not a licensed contractor, and he would not seek to perform any contracting work without the necessary licensure. Again, Ms. Harvey was fully in charge of permitting for this project and for every project that Shoreline Service and Design has contracted to perform, because she is, or was rather, the licensed contractor at Shoreline until her license was revoked by the proper individuals.
When was that?
I can look it up for you. I don't have that information in mind, but I can certainly find it out relatively quickly.
That would be nice.
Yes, sir. The final point I would make for the members is that, and this too is supposition, but Mr. Eady may be mistaken into believing that Mr. Martin played such a crucial role because Mr. Martin was the one who answered the phones for Shoreline, and Mr. Martin was the one who delivered the contract to Mr. Eady. But again, that is the extent of his involvement. He wasn't involved in the designs for this project. He wasn't involved in performing these services whatsoever. And his position is that he should not be held personally responsible or personally liable for the allegations as they pertain to this particular project. I'm happy to answer any questions that other members may have. Otherwise, I will find that data out for you, sir.
Absolutely. Any questions? Mr. Branson?
Yes, Counselor, are you familiar with the proceedings that were last April? Was it April 25th? Were you representing Mr. Martin then?
Our office was. I understand that that was turned over to the Attorney General's office, and I am not aware of any further action that's been taken. In fact, it's my understanding that that complaint, so to speak, has been dismissed. So I'm not aware of any fines being levied against Mr. Martin with regard to that situation or any punitive action being taken whatsoever.
I'd like to, for 1 second, defer to Jeff Madden real quick. Did you have any conversations with Mr. Martin regarding this project at all? And what did he tell you?
Yes, I did. Following the site visit up at the Eady property, I called up Brad because I've known Brad for some time. And when I mentioned to Mr. Martin that I was up at the Eady project, he said, you want to talk about the bulkhead I built? I said, I said, thank you, but I also I'm curious about the situation with Shoreline Services. He said, well, we're in court, but I am Shoreline Services. And while that was a telephone conversation, I have been sworn.
Commissioner, I have a question for Jeff. Going back to April, I seem to recall, and I didn't go back and research it, but Mr. Emmons, I believe, was that case, correct?
Yes, sir.
And he provided copies of the contract that he engaged with, and I don't remember the company. I think it was Shoreline, but I may be mistaken.
With your approval, I'd like to bring Randy up here because I wasn't associated with the Emmons case.
Okay.
It was Mark Eversole, who has since retired.
Okay. But Randy, the documents, the contracts in that case were signed by Mr. Martin. Was that correct?
I don't remember that specifically. I do remember that the testimony from the property owner was that Mr. Martin was indeed the contractor on the scene at that project. And I apologize, I don't have that document in front of me.
Right.
but I know that in.
My point is that.
Yes, sir.
Mr. Martin has acted as a contractor in the past, April, if I remember, and we referred that to the state's attorney's office for litigation.
That is correct.
And I don't know where is that now? Do you know?
That is a matter for Kelsey. I do not know the answer.
Kelsey, do you have an idea where that is? We have a question from Associate Member Branson on where that case is at now.
So it is being worked on as far as I know.
Okay. All right, so it has not been resolved.
No, and nothing's been filed yet either.
Okay, all right. Okay, that's all. I'll ask Mr. Eddy when he comes up.
I would like, the attorney to come up and finish, please. I just wanted to get clarification because when you went down the affidavit road that I was never here, I didn't do it, I had nothing. I wanted to know how his name got, because we don't magically fill in the blank with people's names inappropriately around here. So I wanted to see how he got associated with this project, so.
Again, my supposition is that because he was the one answering the phones, because he was the one who personally delivered the contract, and it sounds like he, at least to my knowledge, was only on site for that purpose. That might be why there's some confusion about his role. But my understanding is he did not take any other further action with regard to the project. He disputes the statements, the characterizations of the phone call that Mr. Madden made. He states that he never indicated that he built the bulkhead, didn't explicitly state that to Mr. Madden, and never said that he was Shoreline Service and Design.
Any questions from, I have one statement after, go ahead, Mr. Erskine.
Go ahead. I just, with reference to the other documented past violations of Mr. Martin, you're aware of those that were presented in this case, the previous 7 violations?
I can tell you, I'm sorry.
Excluding this one we're talking about, are you familiar with those?
I am not familiar with the allegations themselves, no.
Okay. Well, in our documentation, we have these previous violations. What exactly was Mr. Martin's role in those previous violations?
I would have to speak with Mr. Martin about that. We didn't discuss that prior to this hearing because I suspected that the matter at issue today was this particular project and the allegations that have been made that Mr. Martin was the contractor. But I can certainly speak to him about that and provide an answer to you.
Okay. As a follow-up,
Go ahead, yes, sir.
so with regards to this specific case we're talking about today, you're testifying that he was in the office, that was his role as an office personnel, and he only delivered the contract? That's his role in this case?
That is my understanding, yes.
Okay, thank you.
And follow-up is, there's violations, 8 exactly to count in front of me right here. Several of them, I was sitting in this chair with most of this board, and we heard them, and you had 8 issues, and all of a sudden now you don't do anything but answer the phone. That seemed like, to me, it's kind of weird. It seemed to me that conversation should have happened on the front. He should have hired you on number 1, because that happened in 2008. Is that correct, Randy? Is that 2008 that permit came out? Or that number?
I believe there were 6 violations in 2008, 10. Most of them were 2008. And then we have the ED violation and we have the Emmons violation.
Right, okay. That's what I'm saying. So you got 8 total that go back to 2008. Now all of a sudden, we don't know who owns the company and how long it's been defunct. And he worked in the office and answered the phone. Probably should have hired you on number 1. Any questions for the attorney? Said, no further question. Thank you. Is Mr. Edie here and wish to speak, please? Please come forward, please.
Before I leave the podium, did the members want me first to track down the date of the revocation of the license and then also speak to Mr. Martin about the past violations?
Yes, and the chairman asked for the date of the business went out of business.
Yes, sir.
So,
Thank you for your time.
Yes, sir. Mr. Eady, can you raise your right hand? You swear to tell the whole truth, nothing but the truth, so help you God?
Yes, sir.
Can you speak into the speaker and state your name for the record, please?
John Eddy.
Thank you, sir. Thank you, sir. You can go ahead and proceed if you have anything to say before we.
No, I'm quite.
You guys have any questions for Mr. Eady? Mr. Branson?
Thank you for answering the most pressing question, whether it's Edie or Eddie. Thank you, Mr. Eddie.
It happens to me a lot.
Who built your bulkhead?
The original? I have no idea. We bought it. It was there. The guess is 25 years ago.
The one that's pictured in the overhead, I guess, back here.
Yeah, the one that it's the bulkhead and attached to, yes.
And then the new structure, who built that?
Shoreline Construction.
And who was out there at Shoreline Construction during the construction phase, design phase? Did you ever see Mr. Martin?
I did, certainly at the time that he delivered that. We had some serious distress about the schedule. And my wife generally related to him, sent him letters, and they were all addressed to Brad Martin. And the responses came back basically by phone. We're on top of this. We got it. Sorry that we got diverted.
Because of the scheduling?
Yes.
Issues with scheduling? Okay.
Yes. So that's a direct involvement. But just a second, please. Wasn't. He did take phone calls, and he did come to the house.
You know whether or not the number that you were dialing, was that an office line or a cell phone number?
I'm led to be very confused about some communications with Shoreline. Lynn sent Shoreline a letter regarding the schedule, and it came back non-delivered, change your address. She had called over there. What's the new address? I can't tell you that. So I don't want to provide information that I'm not certain of here.
I appreciate that.
I have a follow-up, sir. The contract here that signed, it shows Robin, I can't recall the last name. Harvey. McHarvey? Harvey. Okay. And it shows on the 14th of November. Did that person sign that in your presence? It's
been a while ago.
I know, it's been a couple of years.
I don't recall it directly. But,
you know.
Yeah, I know what you're saying. But
Yeah, because I saw the one that council had provided, and it looks like your initials, I believe, and a date of the 19th of November. I was just wondering if that was signed in your presence by the individual whose signature, Robin, somebody.
Frankly, I don't recall.
You don't recall? Okay. Yeah, no worries. All right, Commissioner.
Any further questions? Stan, appreciate you. Thank you so much. I have one question when the attorney comes back. Randy, can you confirm or deny, has anybody in your shop talked to a Miss Robin Harvey for this project?
Yeah, I believe that Jeff has talked with her on a number of occasions.
I've had a lot of interaction with Robin for quite some time, but I believe she's largely out of the business.
How long ago do you think that was?
Right around, actually, I couldn't get a hold of her during the Eddy investigation. It's supposition on my part, but I understand that they're in court, and she was not available to this office for comment on the Eddy project.
Now, obviously, our office has worked with this company since 2008. Have we ever dealt with Robin Harvey before?
Yes, I have, sir. Yes. She was the point of contact for Shoreline Services for some time, but again, this is this is my thought, is that when the court case started to rev up, she fell off the radar.
I can understand that. Any questions for Mr. Madden? Thank you, Joe. Appreciate it. Mr. Attorney Comey.
So I can tell the members that Mr. Martin is actually currently in litigation against Ms. Harvey related to the business and related to her dereliction of duty in large part. I have a copy of that complaint with me. Although the actual letter concerning her license revocation is not an exhibit to the complaint, I can point out the section of the complaint where we make those allegations with specifics about dates. And I'm just finding that now. May I approach? Staples didn't go all the way through, but it should be pages 10 and 11 here.
Thank you, sir.
Yes,
Thank
sir.
you so much.
And then I can speak to the other violations as well.
Go ahead, proceed.
My understanding is Mr. Martin was not aware of any hearing on those violations. His position is that he did not participate in any kind of hearing. He doesn't remember receiving any notice of a hearing or notice of the violations. But those violations stem from a time when he was solely in business by himself. He was not affiliated with Shoreline in any way, shape, or form. So the practices that were at issue in those violations, I don't think are necessarily relevant to what we're taking up today. And I understand the members may disagree with that position. But part of the reason Mr. Martin decided to become involved with Shoreline is so that he wasn't responsible for some of those duties that may have been the source of the allegations from which these violations stem. He wanted to take a lesser role. He wanted to answer phones, deliver contracts, and that is what he did.
Makes sense. Any questions?
Counselor, do we have the date of that license release revocation for Robin McHarvey?
Yes, sir. It should be on one of those two pages.
Yeah, it's coming, yeah.
I don't know if you recall when it was.
I think she got the license in September 2018. She received an informal notice of 5 different violations shortly thereafter. She didn't respond to the violations, and that's why her license was revoked.
And when about was that? If it's in there, I'll see it when it comes.
It should be in there. I'm sorry, I don't.
December 2022, okay.
That's another aspect of the litigation involving both of those two parties right now. The dereliction of duty, in part because she willfully let her license be revoked. There was no contractor for Shoreline after her license was revoked, and consequently there was no way for the company to perform a lot of its jobs, duties and obligations pertaining to those jobs lawfully, which is why they stopped doing it. And I do have the full complaint if the members are interested in seeing the entire thing. But those 2 pages, I think, speak directly to the revocation of Ms. Harvey's license.
I may have a question for Mr. Madden, I'm not sure, but the notice to comply that was sent, the violation when after the fact was determined, that's sent by certified mail, is that correct?
Thank you. Mr. Eddy was sent a certified letter, and Mr. Martin was served by a Marine police officer.
A follow-up question. So Mr. Martin actually acknowledged that that was received from the Marine police officer?
Actually, he was served twice.
You served twice?
Yeah.
Okay.
Because later on, Mr. Martin retained counsel, and we pushed off the date of the hearing, so we served him a second time. So there's actually two.
Just as a follow-up, is that served by the MPO at a residence or a business?
I would have to, actually, Captain Bell might be able to help that. I'm not entirely sure whether, I'm not sure whether it was served at a residence or whether he was on site. I'm not sure. However, the
They'll
commissioner.
serve you wherever they find you at, but they'll try to catch you at a business wherever it's on the address, but they'll serve you wherever you're at.
So.
Thank you.
If I may just comment briefly on that. Mr. Martin is not disputing that he was notified of this hearing. That's why he's here today. He's not disputing that he was notified of the Emmons hearing, I think is the name on the one from April. That's why he was here for that, and that's why he objected vehemently to what was being alleged during that hearing. I think the hearings that he is stating that he did not receive notice of and did not appear in person for were the ones from, I guess, 2008 up through, but not including the Emmons hearing.
So basically 2008, 2010 range.
Yes, sir.
All the rest of them, it looks like there's 4 2008s and 1 2010.
And I guess the only other thing I would note is the amount of time that's passed between those purported violations from 2008 and 2010 and to the present. You know, the period of at least a decade, if not longer, has passed. And again, I think that relates to why he didn't want to do the business on his own anymore. He wanted to join forces, so to speak, with Ms. Harvey, and that's what he set out to do.
A question, who are the partners of the LLC, Shoreline LLC?
The two current owners are Ms. Harvey and Mr. Martin, but at the time this contract was entered into, it was only Ms. Harvey.
Thank you.
Mr. Erskine.
I'm sorry, I just want to clarify with the previous ones. I understand there's, you know, an issue with those that Mr. Martin is claiming he did have responsibility for, and that's why he wanted to go to Shoreline or a different company. So he's saying he had issues previously with these other applications. And that's the reason he wanted to get away from that, because he couldn't do the paperwork properly. He wanted to go to Shoreline Services.
No, sir, that is not what I'm saying. I don't think Mr. Martin is accepting responsibility for any purported previous violations from 2008 to 2010 here today. I'm not aware of any evidence that's been presented about those violations today, certainly, and I don't have a ton of personal knowledge about those violations. What I'm saying is he wanted to go into business with Shoreline because he didn't want to assume that responsibility for a business all by himself.
Thank you.
Any more questions? I don't have any more. Thank you.
Thank you for your time.
Kelsey, you have anything to add before I bring this before the commission?
No, sir.
That being said, matters before the commission for discussion and/or Mr. Hand.
The staff recommendation was regarding, I think, reporting Mr. Martin to the Attorney General's office.
I believe that's correct.
Can we change that to make it Shoreline Services LLC and its partners, both partners?
I would defer to Kelsey.
Because the most of the question and confusion I'm hearing is
Who's Shoreline?
what person,
Yeah, who's the
what
responsible
entity?
party here?
But let's, if we can take in the LLC and both partners, that takes care of it.
Kelsey, did you hear the Associate Member Hand's suggestion to change the language from the staff recommendation from Mr. Martin to Shoreline Services LLC and Partners.
I think that that's acceptable, yes.
So, all right, we have, is that a conversation or a motion?
I'd like to amend, or.
That, make a motion, because there's no motion
I'd like to
yet.
make a motion to grant the application with the staff's recommendation of taking Shoreline Services LLC and its partners to the Attorney General.
And we've already done the after the fact, so now so you just want to change, basically accept staff recommendations, the motions accept staff recommendations, but change from just Martin to Shoreline Services LLC and Partners.
And I think that should be done on both the, what was it, April issue and the current.
Well, that's passed.
Yeah, I don't know if we can go backwards on that.
Okay, fine.
And it's already
I'm
in our,
happy,
already in
yeah.
our office.
Then let's leave it at the current.
So do I have that's a motion, I have a second? I have a second, Mr. Bransom. Any further conversation or discussion before we go with this? Mr.
I just have a question, and I don't know if this is an issue here, but there seems to be pending litigation. And I'm not sure, I know in the past we've, suspended or tabled issues that come before us with pending litigation. So is that an issue here, or do we move forward with the motion on the floor?
I think, Kelsey, you can chime in, I'm just gonna give my 2 cents. I think, just all we're doing is taking staff's recommendation to see this to the AG's office. That'll be up to AG's office when, how they move forward pending the litigation. I would assume that they would have to wait till litigation's ironed out before they figure this out. But just pushing this up to them for review, they may send it back to us and say, this comes back to the board, so. Mr. Branson?
I would like to add that, in this case, I think sending it to the state's attorney's office for action is the right course, because with pending litigation and the option that Kelsey and the state's attorney's office can depose and do fact-finding, and I think in the legal track is where this needs to simply lay. We're an administrative body. This is clearly a legal issue, and I think it belongs at the state's attorney's office.
Kelsey, you have anything to add, or are you good with us moving with this motion?
Yes, I am. I think that's the right way to do it, and we can consider the pending litigation over here.
Don't worry, Kelsey has no problem if she finds something wrong with it, sending it back to us. We don't have an issue. So I have a motion, and do I have a second from Mr. Bransom? Any further discussion on that? That being said, all those in favor say aye.
Aye.
All those opposed? Motion carries. Thank you. All right. On to the next. Adam, I think it's you, right? Yeah, Adam Andrew, come on up. Andrew, I'm sorry, I read it wrong. I got a lot of A's. I think y'all are like switching on and off on me.
Morning, Commissioner and Associate Commissioners. I'm Andrew Button, the Deputy Chief of Shellfish Management and Head of the Oyster Conservation Replenishment Department. I don't have much of a presentation today, but this should be a relatively quick agenda item, but to give your eyes something to rest on here. Let's see. Oh, what have we got going on here? There we go. Just so you have something nice to look at, I was inspired by Mr. Bransom's picture there of our shellfish management area. So there you go. But something to rest the eyes after staring at a lot of small words for a long time. But this is a public hearing. This is a proposal to repeal a number of regulations. So this is a proposal to repeal the following chapters pertaining to shellfish. They are Chapter 4, VAC 2770, Piankatank River Management Area. Chapter 4, VAC 2780, Patentong Restrictions. Chapter 4, VAC 2790, Open Public Oyster Rocks, Pocomoke Sound. Chapter 4, VAC 2810, Opening of John East, Turn and Pointer Rocks and Closing Beasley Bay Rock and Deep Creek Channel, buoy number 7. Chapter 4, VAC 283010, A Change in the Oyster Cull Size for Oysters Harvested from Russ Rock, Rappahannock River. Chapter 4, VAC 2850, expansion of the Jail Island Clean Cull area. And number 7, last but not least, Chapter 4, VAC 2860, a change in the oyster cull size for oysters harvested from Little Carter's Rock, Rappahannock River. The purpose of repealing these regulations is to really increase regulatory efficiency and decrease regulatory burden. Today, the Commission currently establishes by Regulation 720, so we heard this at last August Commission meeting, restrictions on oyster harvest, the areas of public oyster harvest season, public oyster harvest conservation measures, if they wish these to be different from what's established by code. So the majority of these regulations were in place when the code established oyster season was what we went by, and these were sort of minor tweaks to small areas. When we went to sort of different management strategies, more than 20 years ago, we started doing the majority of what's accomplished in these regulations through 720 and a couple other ones. So repealing these will reduce any kind of redundancy, create any kind of confusion for the oystering public, and generally streamline things in the oyster regulatory world. Therefore, staff recommends repealing the following chapters pertaining to shellfish. So I can read those again for the record, but it's all 7 of those. That's Chapter 770, Chapter 780, Chapter 790, Chapter 810, Chapter 830, Chapter 850, and Chapter 860. That's really all I have for today. I'd be glad to answer any questions on the repeal of these 7 regulations, and there's been no public comment received either for or against this matter.
Andrew, your seasons are covered under all the other regulation. All the seasons are covered under the other regulation anyways, right?
That's correct. So that any of the regulatory intent of these is superseded by that 720. So we're not losing anything important in this, just sort of reducing that confusion and redundancy and regulatory burden.
Any questions? Mr. Headley?
Explain what we're getting rid of when you talk about the Piankatank River Management Area.
So the Piankatank River Management Area is an area established by code similar to the Pocomoke Sound Management Area that allows the commission to establish different harvest measures. And this was just the harvest measures at the time that were established for this area. So those are no longer enforced because they're superseded by Regulation 720.
So what we're getting rid of has no bearing on today's oyster harvest period.
That's correct, yes.
And we don't even touch, and Andrew, step in anytime, but we don't touch these. We address everything through 720.
Mm-hmm.
These were there before 720 was modified to hold everything in. Mr. Erskine?
So, Andrew, is that the same reasoning for the 2.5-inch oysters that you see throughout these repealed regulations, that it's superseded by a 3-inch cull rule?
That's correct. Through our culling regulation, and also in some of these cases, those areas are no longer in open water. So in the instance of Russ Rock there, they're upriver enough, and now that area, unfortunately, is condemned. So there would be no harvest except by relay there anyway. And also, in terms of Russ Rock, there aren't even any 2.5-inch oysters in that area yet. They all died due to freshwater mortality in 2018. Fortunately, there's been a phenomenal spat set, but it might be 2 or 3 years before they even get to 2.5 inches again.
Okay, thank you.
Yeah, that area hasn't been opened in quite a while.
Right.
So, any further questions? Thank you, Andrew. Is there anyone here that wishes to speak for or against this item that's on the agenda? It's just pretty cut and dry. Just doing some house cleaning. Thank you, Andrew, for that, by the way. So if there's no further discussion, nobody wants to speak on this matter, matters before the commission.
I move that we accept staff recommendation.
Got a motion to approve from Mr. Branson, a second from Mr. Erskine. Any further discussion? All those in favor say aye. Aye. All those opposed? Good job. Thank you.
Hey.
All right, now it's Adam. I got a lot of, then it goes back. Thank you, Andrew.
Good morning. This is a a presentation for oyster planting ground application 2022-021. This is not only a hearing for considering the application, but this also was advertised as a public hearing to consider areas that were set aside by this commission in order to remove them from the set aside. So this was advertised as not only a public hearing for those public clam ground set aside areas, but also approval of this application. So the area we are talking about, there are public clamming grounds that were set aside in the Mob Jack Bay area. So there's two separate areas. So this large area you see down here was set aside in 1929 by this commission. And this smaller area up here was set aside in 1930. We're going to look at two different applications today. The first one resides in this 1929 area. The second one resides up here in this 1930s area. This was done by the commission. This was not part of the original Baylor survey. This was not set aside by the General Assembly. These were grounds that were set aside by this commission. At the time, there were 13 individuals from the clamming industry that came in front of this commission and asked that these be set aside for and be open to the public for clamming. And that way they were not used for other reasonable uses of the Commonwealth, such as private ground or other. So it was 13 individuals in both 1929 and then a follow-up in 1930 that asked for this commission to set these aside. And it was granted in 1929 and 1930. So the application is from South Bay Company LLC. You can see the application down here in red. This is in that 1930s area that was set aside. Is a little background up here in the 1929 area. There was a public hearing held in the commission on February 4th, 2015 to evaluate the use of public clamming grounds. At that time, staff recommended to remove the entire 1930s area and open it up to be available for other uses such as private applications. Instead of removing the entire 1930 ground, at that time the commission decided just to remove the ground with the application by Mr. Vigliotta. That area was removed from this public clamming ground and the application approved for private ground. So there is a precedent in 2015 for removing these instead of removing the entire area, considering it on an application by application basis. During that 2015 hearing, there was concerns about SAV, concerns about navigation, safety, and preserving the natural condition. All of these concerns still ring true today. You can see the application we're looking at today does not reside in SAV, although the original application kind of nicks these edges. The plat's a little bit smaller. It is not in an area that is heavily navigated. It's not in an area that is used by a lot of residential. There are, in this 1930 set-aside, there are areas used for haul seine, commercial crabbing, and other recreational uses. Very minimal in this area. Staff has gone out and looked at this application area to see if there are any public resources on the bottom. After survey, it shows that there's little to no public resource on the bottom. It's mostly a sandy mud, so anything sinks way down into it. There's not a lot of natural resource already available on the bottom. This is not an area that is used currently by the public to harvest clams. So that's some background about that 1930s area, as well as the condition of the bottom in the application. The application is asked for 112 acres received by the agency on April 15, 2022. This was, as required by 28.2606, this was advertised in a local newspaper. It was also advertised to nearby or Highland property owners within 200 feet. We got no public protest or no written comments over the previous 2 years. Because they applied on top of public clamming grounds, the agency does not have the ability to approve this application. Because these areas were set aside by the commission, staff cannot unset aside those. So because of that, you'll see in your packet, staff denied this application on September 7, 2023. That denial was appealed by the applicant to come in front of the commission today and ask for that area to be unset aside for public clamming grounds, as well as the application approved. Since the application was put on the agenda, we have received 4 written comments. I believe it's actually up to 5. Those written comments are available in the packets in front of you for you to read from beginning to end. They revolve around that the constituents, these 5 constituents in the area, don't believe that the commission should turn public resources private, that there's other uses in the area, mostly recreational uses, and they believe that public areas should stay public. This is a public area, but it's for commercial clamming grounds, so those activities can already go on in that area. What is unique about this application is when it was applied for, we also send out a use questionnaire. And in that use questionnaire, the applicant indicated that down the line, they would like to apply for a joint permit application in this area for floating cages. That is not currently something that this commission is evaluating today. Staff has not received a joint permit application. That would require another public review, another advertisement, and a more detailed plan. So though it's part of the questionnaire and they intend to use this for cages, for floating cages, there's no actual application, so it's not something that staff is evaluating today. We're just evaluating the use of this area for bottom planting grounds. And you'll see that reflected in some of these public comments, that they don't want floating cages, that by approving private areas, it removes it from being able to be used by the public. I believe the applicant did a good job on choosing an area that's not in front of a neighborhood, not right in front of a navigable channel. They tried to stay away from these other uses as well. The applicant is here if you have any questions for the application. The Code of Virginia 28.2-1205 allows the commission to grant or deny the use of state bottomlands, take in consideration both the public and private benefits. Staff is requesting guidance from the commission to not only approve or deny this application, but based on that approval or denial application, also remove that area from the public climbing set-aside that was established in 1930. I'm happy to take any questions about this application or the public clamming grounds.
Mr. Branson?
Chief, thanks. You said that this public clam grounds was not really suitable for clamming. There isn't any really activity in there by the public?
It's suitable. It's kind of a sandy mud, but currently there are no clams in the area. We went out and surveyed that area and couldn't find any product. So it's not an area that's currently used for clamming, nor is there any resource and any thought to think that there would be any resource anytime soon.
And its suitability for oysters on the bottom, because I see the use questionnaire talks about not using bottom enclosures. That would be just oyster on.
It would just be oysters on the bottom.
And it's suitable for that.
It's a sandy mud. They would probably sink down, and I think that's probably why down the line they'll probably look at a floating aquaculture application. But we don't necessarily evaluate whether or not your business plan is going to be successful. It's whether or not it's reasonable to be able to lease that area.
Thank you.
I mean, to carve out that area and say there's not any clams, the clams are taking a big hit. You know, I mean, that area used to be very, very good clamming, and it's just not now. So to say that area, there's really, my object's been hurt pretty hard, and the Chesapeake Bay's been hit pretty hard when it comes to clam in general. I mean, look at Hampton Roads. You know, so, I mean, but anyways. Any further questions? Mr. Erskine?
So, Chief Kenyon, so the dark blue area represents the totality of the public clamming ground that's set aside?
Not the totality. So if we go back to this blue, so the zoomed in picture I had is right about right here. So this entire blue area is the 1930 set aside area. If any public resources available, it's more down here. This small section up here was the original 1929, or I'm sorry, I had that backwards. This is the 1929 set aside. This is the 1930 set aside. So it's much larger than this small 112 acres that we're looking at.
All right. Thank you.
Any further questions for
Good
Adam?
question.
Mr. Haynes?
So I'm assuming that with the public use ground, there's no aquaculture, that it's just, wild clams.
Correct.
Find them. So in effect, that area would go from that to aquaculture being allowed. Yeah,
Correct.
that's how
It
I'm-
it
that's
would
how
be
I'm seeing
open
it, just
for
a
an
simple-
application which we'd receive, and that application would do private aquaculture on the bottom.
Okay, thank you.
We have another one after this too? Same
There,
thing?
there is another one that is very similar. You can see this green square up here. There is another one that is very similar in nature, being able to remove the set-aside area, although that has some nuance with the advertisement, and moving forward, it is kind of the same question, whether or not this commission would entertain removing the public clam grounds underneath in order to accept and approve these applications.
Minus the 2015 issue, basically you're saying we're getting ready to open the floodgates on public bottom.
In 2015, staff recommended removing the entire 1930s area. Rather than removing the entire 1930s and opening the floodgate, the commission chose at that time just to remove this area. And then if other applications came in, they could actually address them on a case-by-case basis versus just opening up the floodgates.
Yeah, I think you've already opened them, buddy.
And what we're discussing today, Chief Kenyon, is just that application.
Just this application by South
Not removing
Bay
the public ground set-aside area.
Correct.
In either one of
Correct.
these cases.
Staff is not suggesting to remove the entire areas. Staff denied this application because it's on public clamming grounds. That was the only reason staff denied it. We do not
Because
have
of
the
the appeal.
ability.
Right.
Yep.
Yes, sir.
So I'm asking for an opinion. Is that area suitable for either oysters or clams on the bottom?
Had this not been in a public area, there is nothing in the application or in the written comments that would force staff to deny this application. It would have been approved based on, we had, at the time that we had to approve or deny this, we had 0 written comments. And the only reason it was denied was because it was on top of public clamming grounds. We did not have the authority to do that. Other than that, it would have been approved by the agency.
Well, I'm asking, is the bottom suitable, like the
I have
consistency
not
at the
been
bottom?
out there and seen the entire 112 acres. The surveys that we have say it's kind of a sandy mud. Some people say it's suitable for on the bottom. Most people will say that your product would sink into the area, that you would have to do it in cages or apply for floating cages after.
Thank you.
Any more questions? Mr. Hadley?
I don't think this is a question. This is more of the way I feel about it. But I think if we keep stabbing at the public ground, eventually we're going to get rid of all of that public ground set aside, and it's going to be turned into leases. And then the public will not have anything left. Traditionally, York River, Mogic, and everything was a high clam yielding area. And I personally would like to still see that it be possible if the clams did decide to come back.
And the applicant is here, if you'd like to hear from the applicant on the
We'll get to
application.
him in a second. Him or her in a second. Any more questions? You know, I caution this board on how we carve out public bottom of any kind. Remember, the public resource is for everybody's use. These areas that are public, when they're open, as you know, you can, if there's clams there, you can go scrape them up with your hand rake and stuff like that. So as we lease these up, we lose them. So just be cognizant of that. And I get also, be aware of, if you lease it out, you're taking away areas to be able to promulgate possible put reefs and stuff like that at, if it ever becomes suitable. We're limited. The bay's not, you don't have unlimited acres. So, any more questions before we move on to the applicant? Thank you, Adam. Is the applicant here? Like to wish to speak, please. Please. Raise your right hand. You swear to tell the whole truth, nothing but the truth, so help you God?
Yes, sir.
Please state your name for the record.
Sarah Matheson Harris. Good morning, Commissioner Green and associate members of the commission. My name is Sarah Matheson Harris. I would first like to establish that I am the sole owner of both Matheson Oyster Company, LLC, and South Bay Company, LLC. I understand that the reason I've been brought in front of you today is because I have requested a lease that currently sits within an area designated as claiming grounds. Please know that I understand the weight of this issue in regards to the public trust doctrine. I hope the following outlines how the intended use of this lease, if granted, would be of the highest benefit to the Commonwealth of Virginia and the resource held in trust. I come to you in regards to this lease via a path that had several roadblocks to starting my business, probably like a lot of us in this industry. I intended to start my business with 2 leases totaling 8 acres that were handed down to me by my father. I originally planned to start this business at a very small scale. However, I quickly found that homeowners and oyster farms tend not to mix all that well, even in front of your own home. My first interaction with the VMRC actually led to the success of my business. Once faced with opposition, I was presented by people in my local community with the opportunity to purchase part of a historic working waterfront in Hayes. I honestly believe those who recommended this opportunity did so with tongue in cheek. At the same time, while evaluating whether or not to take this opportunity, I received a 22-acre lease from the state that was accompanied by a JPA for a suspended longline farm. I have now been presented with the opportunity and need to restore and utilize the other half of the historic working waterfront. From my experience in doing this once already, these sites require a great deal of support and resources. The importance of this lease allows for that waterfront to fully utilize all of its assets and in turn will provide continued resources for its restoration. Trying to farm the lease in front of my house was the first but not the last struggle in acquiring leases. To those in the industry and to those who come into contact with the state's resource, the contention between spite leases and available substrate has been a long discussed matter, often highlighted in the Virginia Coastal Policy Center of William & Mary. For very salient numbers as to how unproductive the MOBJAC is for the industry, you can look no further than the Virginia Oyster Productivity Tool available through the VIMS website. This is one of the main driving reasons that I put forth this application. It would seem that the same constraint led to claiming ground further into the MOBJAC in 2015 to have been granted to a private company. That specific action has helped lead to a very successful company today. While other companies would solely use it for aquaculture, it is truly my intent to try to replenish the substrate. If I'm not successful, I guess I will be feeding a lot of crabs. And I would like to point out that this application was in 2022, and just as life, my interests have evolved a bit, so further into this discussion, you will further understand my interest in the substrate. In building my business, I've developed key identifiers that create an ideal leasable area. I've mixed that with key issues laid out into the Virginia Code that instructs the VMRC in evaluating the best and highest use of the shared resource, along with issues that have organically risen from use conflict. We have mixed these topics into a weighted average formula which drives decision-making. 1, this site and the upland property is extremely remote and has no residential neighbors. It is completely outside of anyone's viewshed. Second, this lease is situated so that in the spring and summer, it is calm and easily manageable in the southeast blow. Lastly, the depths of this lease and also the substrate make it an opportune site to try new and innovative techniques in mixing aquaculture, diploids, and traditional setting. I plan to replicate this methodology, which is to rotate plantings and gear placement. And as always, in regards to intended leases that I apply for, it is outside the navigable channel. In evaluating this lease and all of the leases I have applied for and have had pending since 2020, this lease ranks second in importance. The only other lease more important involves a sublease that I have with someone who is now a good friend within the Hayes community and is located next to our working waterfront. For the future of my business, I have identified a couple key products that present opportunities both for myself and for the Virginia oyster market. I have had growing interest in a brand of roasters I've trademarked as Bonfires. I have engaged in conversation with a health-focused food mart group that would like my Bonfires to be diploids. I've also been asked by other companies to grow oysters for the shuck market. The current use of this lease seems to be minimal. When first engaging with this topic, a survey for clams was to be conducted, and it's my understanding that the survey produced no yield of commercial scale. I have a great business, one that has been very tough and very rewarding, and I've been able to capture a decent amount of success thus far. In conjunction, I have succeeded in revitalizing one half of a historic working waterfront in the Hayes community. The addition of this lease will not only allow for me to continue my current commercial activities, which will require hiring more people, but I will also need to rely on the skills and expertise of the traditional watermen in my community. I want you all to see that this is a serious quest and the opportunity that would be magnified through granting this lease.
Any questions? Any question for the speaker? I don't have any questions either, but thank you.
Okay.
Mr. Erskine?
Thank you. So were you indicating in your comments that the use questionnaire that you filled out has changed?
This has evolved, I would say. My interest is to look at some of the techniques used in other places of the world, particularly in France, for example, in Canada, where they'll grow oysters to about 1 inch and then use that to also plant in the substrate. And so what I'm interested in doing is doing gear rotation of floating aquaculture cages that, as Mr. Kenyon mentioned, would require a granted JPA down the line, but then also mixing it with the traditional planting that I would be able to work with some of the watermen in my community to help with.
So just as a follow-up, so it's still true that you may, I guess in this questionnaire you indicated you may apply in the future for suspended or floating
Yes.
gear.
If granted, yes.
And that obviously you understand is a separate process.
I do.
Than this. But then you would also go back maybe and use the bottom, because you indicated no, you would not, shell the bottom or use the bottom and things like that. But maybe that would take place. So we're trying
Correct.
to make the bottom productive as well as.
Yes, and I would say that interest really has evolved from working in this historic working waterfront in the Hayes community, often called Guinea.
Thank you.
Yes.
Any more questions? Thank you.
Thank you.
Is there anyone here that wishes to speak on this matter in support or in opposition? Please come forward a bit. Raise your right hand. You swear to tell the whole truth, nothing but the truth to help you God?
I do.
Please state your name for the record.
I'm Ben Stagg. I'm the Executive Director for Shellfish Growers of Virginia. Shellfish Growers of Virginia supports the public fishery, the clam and Baila ground fishery. However, in this particular area, this is not Baila ground. This is a public clam ground. It was set aside by the commission, so the commission has the authority to modify it. It is difficult for new industry people to get into the industry to find suitable areas. We do believe this area is suitable for the type of activity that's being proposed and might warrant careful consideration of removing this small section. We understand the piecemeal approach is maybe not the best. Previously, that upper area that was the 1930 area, there was a staff recommendation to remove that entirely and make it leasable. The commission opted to go with just the one spot. You'll hear a subsequent application for that later, but for this application in this area, it's also in an area that's not inhabited in the adjacent upland, which is a bonus for aquaculture because of the conflicts, user conflicts. It's not in a highly navigated area. It's not a channel there. So in essence, SGV does support the request to remove this for use as leasing. I'd be happy to answer any questions.
Any questions for Mr. Stagg? Thank you, sir. Anyone else wish to speak on this matter? Please come forward. You swear to tell the whole truth, none but the truth, so help you God?
I do.
Please state your name for the record.
J.C. Hudgens. I'm president of the Virginia Watermen's Association. And first off, I'd like to ask Adam, the light blue section, is that present lease bottom?
The holes in there?
The light blue area
Close to the
inside of the
shore,
red?
right against the shore?
This area right here.
Yeah.
No, that is not currently leased area. That is public ground area. What you're seeing is submerged aquatic vegetation as mapped by Virginia Institute of Marine Science overlay.
Okay. Thank you. Well, I'm really not in favor of the watermen losing any more of the clamming grounds. I agree with Commissioner Headley and Commissioner Green. I think this is probably not going down the right road. I'm really, really concerned in the future, how many more of these sections that we're gonna see cut away from our private clamming ground. So I think, right now, I think it's really not the best way to handle this. Certainly the watermen would like to see it stay as a public clamming ground. So, I'd be glad to answer any questions on it.
Any questions from Mr. Hurst? Mr. Erskine?
Mm-hmm.
JC.
Yes, sir, AJ.
So I appreciate your public comment
Mhm.
and the fact that this is important in general, you know, for the
Mhm.
watermen to maintain public ground, which I agree with. This has been set aside for obviously a very long time.
It has.
What is the history in there? I mean, currently, staff said that there's little resource there. Historically, has it been productive? You know,
And-
do you know?
It's been some years ago. Most of the viable clamming grounds were actually out further in the Mobjack. But it doesn't mean that in the future that clams can't come back, you know, in some areas, just like oysters. I mean, depends on a lot of factors, you know, whether the clams come back as the oysters, it could be oysters or clams, you know. So this particular area, I don't think it does have any production at the present time. I know of several guys that do. They do a lot of private oyster dredging in the summertime. I know several that do clam in the Mobjack in the summertime. So it is producing clams. Not sure about this particular area right here.
Okay, thank you.
Okay? Mhm.
Any more questions? Thank you, Jason.
Okay, thanks.
Anyone else here wish to speak on this matter? Raise your hand. You swear to tell the whole truth, nothing but the truth, so help you God?
I do.
Please state your name for the record.
Nancy Smith.
Proceed.
I just, I know this is not in a heavily trafficked area for recreational boating or canoeing or kayaking, but I live on the Ware River, and we have enough aquaculture in the Ware River. And I think this will set a precedence to open it wide open. You're going to have so many applications for this clamming ground, and we'll have more and more and more aquaculture. There'll be nothing left for us boaters to do. That's all.
Any questions from the commission? Thank you, ma'am. Is there anyone else that would like to speak on this matter? That being said, matters before the commission.
Commissioner,
Yes, ma'am.
I have a question, actually maybe for VIMS. And I just have a question about the wild clam population and clam harvest, because I know that on the seaside, in my neck of the woods, that fishery has declined also. And I just wondered if VIMS would speak to
Pretty bad.
speak to that and what the, I don't know, maybe the outlook is, and if that might help shed light on this particular area.
Mark Lukenbach. We don't have any data on the harvest. VMRC might have that. What you get in this area and up in the Mobjack, in parts of the York River, you get really age-dominated, age-class dominated populations, because when you get a wet spring, the juveniles, as you know, just aren't going to make it below 19 parts per thousand. And so you can sometimes go a bunch of years with no recruitment in these areas. And certainly that far up the river, not further out in the Mobjack, has got lower salinities. So it's not a disease issue. It's not an overfishing issue for those. It's just that recruitment of new individuals is really sporadic.
So it's a habitat issue?
It's a salinity issue and survival. The big ones, you know, the larger ones, as you know, can survive a good set of freshettes, but you just miss those year classes when there's a lot of runoff and it's wet, right when they settled. And again, maybe VMRC could speak to what the actual harvest would be. I don't know.
Thank you.
Good, Andrew.
Yeah, in terms of the wild clam harvest, I think Mark is exactly correct that, you know, that's what's going on population-wise. But also the harvest effort just isn't there like it used to be, in part because the clams weren't there. So, for example, there's less than 6 folks right now, more or less, recently patent-tonging clams on the bayside, and not very many folks hand harvesting or clam dredging. I think there's 2 or 3 boats clam dredging on the seaside, so that's harvest and population dynamics showing up. But again, there are clams in this area above and below, but how often and how dense we don't have great data on. But they can exist there, but there weren't any that we saw on the bottom in this particular location.
I think, as you know, and I'm sure JC will attest to this, you don't have clammers there because it's like the supply and demand issue. Usually if your supply is down, the demand goes up and you get a lot of money for your product. Well, as much as the clam stocks have fallen, the price hasn't gone up that much. And so they're not really it's not a real viable, you know, if you can go oystering or crabbing or anything else, this is going to be an absolute last resort for most people unless they have some sort of side market. Because the price is just, it hasn't gone up with the catch going down. I would say 6 is probably a good number. I don't know the last time I've seen 6 boats of object at one time clamming. Any more questions? Anybody else here want to speak on this matter before we move forward? Raise your right hand. You swear to tell the whole truth, nothing but the truth, so help you God?
I do.
State your name for the record.
My name's Tom Burkett. I would urge the commission, before taking land away from public set-aside ground, to create some sort of protocol for the public to open up proposals for such land. Hearing individual permits to piecemeal off public set-aside land would break the ability for competitive proposals for land, and to also see what the land itself could be most valuably used for the public.
Any comments for the speaker? I know this a little bit backwards. No, thank you.
Thank you.
All right, that being said, matters still before the commission. We operate on motions. Mr. Headley?
I respect South Bay Company's request for this application, but being a commercial waterman myself, I do believe that if we do have any public ground set aside, that the more we take away from it, the less options the watermen have. That being said, I make a motion to not approve this application, to deny it.
Do we need a motion to deny, Kelsey?
They asked for him.
To be safe, it keeps the record a little cleaner.
All right. So I have a motion to deny from Commissioner Headley. Do I have any further discussion and/or a second?
I'm also concerned, Commissioner, with the chipping away at the public ground set-aside areas, and that's why I'll second the motion.
I have a motion to deny and for Mr. Headley, a second. Mr. Branson, any further discussion? Mr. Erskine?
So I first want to thank the applicant, for coming up here and giving a great presentation, and congratulate you on a successful start to a business. And this obviously is a difficult issue involving private leasing and public ground. I appreciate both sides. I think, there are some areas once you get into maybe you start to break that apart, and it might, be an issue for the future with the public watermen getting pushed out. I do know there's, as the applicant indicated, some sublease, opportunities to obtain, ground. The last public comment about maybe a process, should there be areas that would be available to the private leasing, maybe something that this commission or staff looks into in the future. I don't think this is the last time we're going to hear this. So I just wanted to provide, I guess, some perspective that
this is an issue that I don't think is going away. Obviously, floating gear is a completely different topic, but just leasing private ground in a public area and taking that away from the public trust is going to be an issue we're going to continue to see.
Ms. Lusk?
Yes, I also have a comment. Would echo the thoughts of Commissioner Erskine, and also commend Ms. Harrison for her presentation and her willingness to experiment with new growing techniques and bringing new ideas to an evolving industry. And I also appreciate Commissioner Headley's concerns about public ground. I think it's true that this is going to be an issue going forward. It doesn't end here, you know, with the growing industry, land, ground for expansion and for new players such as Ms. Harris to come into the business is extremely limited, especially given the back and forth between homeowners and industry. And it is very difficult to find appropriate ground. You know, you try in front of your house, that makes people upset. You go to a remote area, that makes people upset. Where's there to go? And so I certainly understand that. I think that it's important to respect traditions of the public ground, but also we're an evolving world, an evolving environment, and it's also important to be able to be flexible. I would be willing to approve this lease, but in the event that this motion to deny passes, I think that it is a really good idea to look at a process going forward, because as Commissioner Erskine said, I don't think that this is the last time we'll see this.
Thank you. Any further comment? We have a motion and a second. That being said, all those in favor to deny the lease, say aye.
Aye.
All those opposed, say no.
No.
One no. All right, Ms. Lusk voted no. Motion denied, 4-1. Proceed, Adam.
The next item on your agenda is very similar in nature. This is Oyster Planting Ground Application 2021-013 submitted by Mr. Richard Green. It is similar to the last one, as it was also advertised as a public hearing. There are two parts to this. One is a public hearing considering removing an area set aside by the commission in 1930, and the second would be to consider the application at hand. So exactly like the last application, the area you're seeing on the bottom is set aside in 1929. That's the larger area. The area that we're looking at today is in this upper area. This was set aside in 1930 by 13 individuals that came in front of this commission. This commission decided to set aside those sides. It is not Baylor ground. It is not set aside by the General Assembly. So this commission has the ability to unset aside it. As you know, so the application 2021-013 is for this red area up here. It is further up in the Ware River. A public hearing was held by the commission in February of 2015 to evaluate similar usage in similar areas. In 2015, this light blue application was granted by the commission, as the area underneath was removed from the set-aside area. It's rather than going with staff recommendation of removing the entire 1930 set-aside, they decided it was best to be able to look at these applications on as they came before. So that's why we are before for this one. There are concerns about SAV, navigation, safety, and preserving the natural conditions. These were all prevalent in 2015, and they reside in the same areas in the same place that today. The application we're looking at is for 250 acres in the Ware River. The nuance to this application is once staff saw that it was applied for on public grounds, we stopped the application process. This application has not been advertised under 28.22606, meaning that it has not been advertised to the public in the newspaper. It has not been advertised to adjacent property owners within 200 feet. Instead, staff thought it was prudent to bring in front of this commission and have a public hearing about the set-aside ground underneath. If the commission is not in favor of removing that set-aside area, there's no reason to further go through this application. If the commission believes that they want to remove that set-aside area, staff would then require the advertisement. If there is substantial written comment from that advertisement, we can bring that back in front of the commission for approval of that. If there is no substantial public comment, staff has the ability to approve it and the set-aside area would already be removed. So this is a little bit out of order as far as it being publicly advertised, but it's essentially the same question. Would the commission consider removing the set-aside area underneath this application and open it up? If so, we already have the application in hand. We will proceed as normal. Staff did send a denial letter on September 7, 2023 to deny this area as it was on top of public clamming grounds. Since it was put on the commission agenda and publicly advertised for this meeting, staff has received 13 public comments. All the comments are in opposition to removing this set-aside and granting this application. They revolve around similar things as the last ones, that they do not believe that they should remove public grounds and create private areas. There are other recreational uses that go on in here, such as boating and swimming and things like that. And removing the public ground would remove those opportunities, whether it be through bottom cages or subsequent floating aquaculture. The use questionnaire for this application indicated that this applicant did not intend to do any kind of floating aquaculture. Everything they intended to do was traditional on the bottom shelling and scraping of the bottom. This is not, this is an area, as you can see from the map, that this is not, would not set new precedent as far as that kind of activities. Those kind of activities already go on in the area. It would just be removing that set aside and approving to move forward with the application. So staff is requesting guidance from the commission on whether to proceed with the application process. The Code of Virginia allows the commission to grant or deny any permit, as well as allow the commission to set aside specific areas or remove certain areas from this set aside. So I'm happy to take any questions about this application.
Any questions from the commission? Mr. Headley?
I stepped out in the beginning of the presentation, but is this the same exact situation that we just heard?
It is extremely similar. The only difference is what we looked at in the last one was from this below, this 1929 set aside. This is from this 1930 set aside area. And this small area right here was removed from the set aside in 2015 by this commission.
Okay.
The only other nuance to this is it has not been publicly advertised yet. If the commission agrees to remove the set aside, staff will publicly advertise this to come in front of the commission. If there's substantial opposition to it, we'll bring it back in front of the commission, and the commission can always decide to reset that aside if the application isn't warranted at that. But there's no reason to move forward with an application if the commission did not support removing the set aside.
Okay.
So a little bit different,
Follow up.
but very similar.
Good.
Do any of the watermen's associations or anything get notified about a possible change to public grounds beforehand?
They do not get specifically, that's why this was advertised as a public hearing rather than just looking at an application. So our advertisements for public hearings get posted on the town hall website, get posted on our website, as well. So there's a larger area, but no, it's not specifically sent to the Watermen's Association.
Thank you. Any more questions for Mr. Kenyon? Thank you, Adam.
And the applicant is here and present if you'd like to hear from him.
Is the applicant here and wish to speak? Please come forward. Does the applicant wish to speak?
I can keep my balance.
Please. Raise your, you swear to tell the whole truth, nothing but the truth, so help you God?
I do.
Please state your name for the record.
My name is Richard Green, members of the board, Commissioner. I'd like to say it's sort of similar with the previous, at least that was requested, but this one is different. The original one was set aside by the commission, but the second one, this piece we're talking about right now, come as a fact of a group of people come together and petition to have it added to that. They've already, he said one, no, you've already had two pieces of bottom that's already been granted. Vigilante had a piece, and this lady's got the second piece on the thing in there. And I'm going to come under the same idea of what they done. If it was fair for them to get the piece, this piece of ground, this particular has been open for oyster ground. And I come under the same deal that they requested theirs. That's what it's been leased in it before, so it should be now. Outside in the permanent pieces of ground, I'm kind of like y'all in that thing. I'm a commercial waterman, been most of my life. I've been a Patton clammer. I've clammed all these areas. I know what's there and what's not there. And I know what these bottoms look like. But this piece up here, being that it has been leased into, I'm coming under the same, I'm requesting under that same idea that it was done before, and y'all had granted it. So that's what I stand on. Everything else has already been said on the previous ground, all the areas and what's been done. It's no need to rehash all that information over again. But that's the pretense which I'm coming requesting this piece of ground. That's what it was from the beginning when I first put in for it. That it has been, and it should still be legal to lease within this perimeter, even though it's a small perimeter. And I would imagine this would probably be the last leasable piece in there, because between that and the shore, it's nothing but soft sand, shifting sand on the bottom. You can't do nothing. You can't plant on it. It's not very good for anything. The piece that I put in for is 250 acres. I actually didn't need all of that. I could probably wind up cutting that back smaller. With this decent bottom up towards the piece of, I guess that's a Baylor survey piece of ground in there, if I'm not sure. I think it's a state piece of ground. They don't have it showing there, but that's pretty decent from, I'd say over half, 2/3 what I put in for. It would be good, workable ground. So that's the pretense in which I'm requesting this lease for.
Any questions for the applicant? Thank you, Mr. Ray. Thank you.
Thank you.
Is there anyone else that wishes to speak on this matter, for or against, in the audience? For or against? Please come forward. You're already sworn in. Just state your name for the record, please.
Ben Stagg, representing the Shellfish Growers of Virginia. As I stated before, we support the public fishery. We understand the issues here. This is an addition to an area that was removed that Ward Oyster Company did lease. And by the way, for the commission's edification, those blank areas on your map that aren't colored, those are public grounds. That's the Baylor ground that are not colored in. So this would adjoin Baylor and would be removed from a small section of the clam ground. So we do support the request to remove it. Thank you.
Any questions for the speaker? Thank you. Anyone else wish to speak on this matter? Please come forward. Please run in. You swear to tell the whole truth, nothing but the truth, so help you God?
I do.
Please state your name in the microphone for record.
Sean Smith, Ware River resident. Good morning. I guess two things that I'd like to comment on. First off, the public piece that the gentleman spoke about that was not part of this particular application, but was part of the other one. Anytime that there's a public piece that's taken out, that I would caution that the people that are involved in that are not being represented fairly, and the commission should definitely consider that. The other piece too is this particular area of the Ware River has a lot of recreational boat usage. The Ware River Yacht Club is there, and there's a lot of children and sailors that use that area. This would impede them from using that open waterway because it encroaches where the current piece is, where Vigliotta has his piece. This juts out even further into that navigable recreational waterway. So,
Questions for the speaker? Thank you.
thank you.
Is there anyone else here that wishes to speak on this matter?
I'd like to add something to that.
I'll give you a few seconds. Please state your name for the record again.
Yeah. Richard Green. I'm not gonna be using no poles or putting no floating devices or nothing. This is strictly gonna be bottom oyster, we're planting on the bottom, and we're putting minimum amount of poles that is necessary just to show the area that we're using. So I can't think that it would impede any kind of recreational vessel. And they're more than welcome. If it's my ground, I got ground all over the place. They're welcome to go on at any time. But it would also add to more fishing areas. You know, the shells on the bottom, your fish and stuff feeds on that. So as of right now, there's nothing there. So it would probably be a help to them rather than a fallback.
Question, what's the water depth in that area from the
I'm
shore?
sorry, my hearing-
What's the water depth from the shore area and to the Baylor ground there to the south?
Right at the Baylor from back, that's gonna be my primary concern. As you get further out, it's around 20 feet of water as you come towards the offshore Baylor piece. Inside there's about 14, anywhere from inshore from about 10, 12, as you come off to about 14, 15. And then when you leave the ground, it begins to deepen off a little more. So the actual best of the ground is right next to the Baylor running over.
And it's deep water.
It's fairly deep. It's a little, about around 15 feet, 14, 15 feet long. Someplace a little better.
Any questions? Thank you.
You're welcome.
Anyone else want to speak on this? Thank you. Matters before the commission. Mr. Erskine.
I have a question for staff. So the two areas, or maybe three up there that are dark, are public Baylor oyster ground.
Correct.
Are they productive? Meaning, are they worked? Are they in the rotational harvest, and are they producing harvest?
These areas are not currently in any rotation. There may be some oyster resource there, but they're not currently in a harvest rotation. So they're not actively being harvested right now.
Okay. As a follow-up, maybe. So are they proposed to become part of the rotational plan in Virginia, or what's their outlook on those pieces of public? I'm talking really about the two that would are adjacent to this proposal.
There hasn't been any proposals offered by staff or any of the advisory committees on anything with these particular pieces of Baylor ground. I think at the moment there's probably minimal resource there. There may be some patchy areas, but these are areas that have been historically hand-tong areas that haven't been open to harvest in 30 years and mostly sanded over with some shell based on sort of a very, very loose survey of the area. So not a significant amount of resource currently there. So likely to get them back to harvestable levels would likely take some increased replenishment effort.
Okay, thank you.
And just as a clarification on one of the commenters, staff is not suggesting that we remove the public portion of this. Staff is asking on guidance from the commission if they wish to set aside this area, and if so, to move forward with the application, including the public notice.
Any further questions? Mr. Hadley.
The same kind of statement as far as the last one, as far as it being public, and myself, and I do feel that I would speak on behalf of a lot of watermen, saying we would not like to see anything that we have taken away from us for a single user fee. That being said, considering there's Baylor grounds on both ends of that, I guess the south and the east end of that, another benefit to keeping it at a public clam ground would be a buffer between the Baylor grounds and the private too.
We hear that all the time, especially from industry. questions for the speaker? I mean, I'm very familiar with this area as well. I was born and raised in this area, so, yeah, not, used to be an island on that upper end, but that point is just completely gone now. That was decent size a few years ago. I'd say 2 decades ago. It's gone now. There's not even a tree there. Keith Nuttall, for those of you who might know, I'll entertain you a little bit, grew up just inside of that red polygon there. That's where he was born and raised at as well. So, very familiar with the area. Production hasn't, as far as the Oyster Public Ground, that hasn't been open in so long that it ain't worth talking about. So, but there is a reef inside of that public ground that we put in and have had seen some success of life in there on occasion, so. That being said, is there anyone else here that wishes to speak on this matter before I put it before the commission again? That being said, matters before the commission. Mr. Hadley.
Considering my last statement on the last one, I do not feel that it is right for us to take public grounds until there is more research done to appease both sides of the group, the public, the watermen, everybody. So I make a motion to deny this application.
Motion to deny. Any further conversation, discussion on this matter, or a second? Discussion.
A second.
Got a second from Mr. Hand. Got a motion to deny from Mr. Headley, a second from Mr. Hand. Any discussion?
Just like Mr. Headley, I would sort of repeat my comments from the last part. I think that we probably mostly are on the same page. I would tend to fall slightly on the other side, and I would consider this lease, but I do think it's very clear that you know, regardless of what happens with respect to this particular application, I think as a whole, there needs to be some discussion about how to move forward with
I'm gonna add some of that in.
with the lack of bottom for both industry and public. So, you know, I would be in favor of approving the lease, particularly because it's an opportunity to make unproductive bottom productive, especially given what we know about the value of the habitat value. I think Mr. Green mentioned, you know, maybe enhanced fishing opportunities, et cetera. But in general, I still think that certainly some conversations moving forward would be very helpful.
Absolutely. Mr. Harrison?
So I appreciate the applicant's, again, interest in leasing ground. I think, you know, VMRC and the state has done an excellent job of balancing public and private resource, and obviously in recent harvests that's been, you know, productive, and this industry has survived difficult times and come back in part because of public and private. But this is not just going to be an area in contention maybe in the future with public clam grounds, things like that. There's several areas that are SAV set aside. Some probably that have SAV and some that do not. So, you know, it was many years ago that you had public and private, you know, set aside. And it's a lot more public ground out there than there is private ground. So things change. And I appreciate, you know, fellow commissioners that, you know, say we're in this situation where we have a set aside. But I do think in the future, maybe we need to look at these areas, and it may be an opportunity to, you know, lease these things privately. Things are going to change, and you know, I know the issues on the Eastern Shore as well as this area in particular. So we're just going to have to be vigilant going forward, and maybe there's an opportunity for staff to develop something that this commission can look at for guidelines. Thank you.
That being said, we have a motion and a second. All those in favor say aye.
Aye.
All those opposed?
No.
Okay. Motion passes 4-1. Ms. Lusk. Voting no. Before we move on to the next item, I'd like to throw my last words of comment on on these last two items. I am very uncomfortable moving forward on any public bottom issue, whether it's set aside by this commission or not, without first consulting our scientific advisors on what is the best use for this area. What are the best? Because we're sitting here protecting the public trust for everyone. And yes, I agree that we're running out of areas to do aquaculture. Well, we know that. Even when we give all this area away, where we're going to go next? You're not going. I mean, you're eventually going to run out, no matter how you look at it. That being said, limited ability and availability. We have limited licenses for everything we do. We have a cap on every commercial fishery. We have a cap on how much leased bottom we have. We have a cap on everything we do here. And that's typically part of our regulatory management process, and some of it's been developed for years, and it oftentimes is, picked at and changed and evolves. I like the term evolves because we do have to evolve, because the fact is, Ms. Lusk and Mr. Erskine is right. There are any clams here. There are any clams here. So it's called clamming ground. But I do agree. I think we need to work with our partners at VIMS and get staff to partner up with VIMS and see what is the best way forward. Instead of just allowing one or two people to just lob in here and carve out items. I had a comment about Mobject Bay Seafood, Mr. Vigalotta being successful after he got that ground. Mr. Vigalotta was successful long before he got that ground. So, pretty sure I'm familiar with the area. So, that wasn't necessarily the part that got him over the hump, so to speak. So, but yes, I agree. The ground is not being productive, but we need to find a way to move forward. But I would like to see what you guys got to say. One thing we also got to remember as we carve out these grounds and lease them out, we take away areas for possibilities like reefs and other new and exciting opportunities for science coming along that may give us something we don't know about, because we probably are not going to get permission from a leaseholder to put it there. So that being said, I will task staff with getting with VIMS and seeing what it is, because I do agree with Ms. Lusk here. We need to look into it, and if we're going to do it, we need to take a strategic approach and lift it in a manner to where we're not just throwing the baby out with the bathwater. So, moving on to the next one. Thank you guys for that. Public comment. So I know I have Mr. Eskridge, are you here? Would you like to kick it off? I know you contacted me. Can you come forward? I know you came a long way, so we'll start off with you, and then we'll grab them as they come. Raise your right hand. You swear to tell the whole truth, nothing but the truth, so help you God?
I do.
Please state your name for the record.
My name is Tommy Eskridge, commercial fisherman, Tangier Island. I started full-time commercial fishing right out of high school when I graduated. My first oyster, the first time I ever oystered when I was in the 8th grade. I would go oystering, shaft honging on Flat Rock east of Tangier after school in the evenings. But anyway, I've held an oyster license for quite a few years, and I've kept up with my user's fee up until last year. Even on Tangier, it gets busy, hectic, a lot of times in the summertime, and seems like for me it's really busy in the summertime. But I neglected to buy my user's fee for my oyster license. So of course, when I went to purchase my new license last year, I get all my licenses together. It was denied, and I didn't even realize I had forgot to get it. So I'm here today to just respectfully request that you guys reinstate my oyster license. Being on Tangier, I don't really, have a lot of options, and commercial fishing is what I do. It's what I've always done. It's what I'm going to continue to do, I hope. So with that being said.
Mr. Eskridge, last year, the first year, you didn't purchase it? Or did you buy it every year before that?
Yes, I was required to, since we've been required to purchase them in order to keep them, yes, I've been buying it every year.
Any questions, Mr. Branson?
How many years have you had your oyster license?
How
many years you've been renewing it, basically?
Well, I've been renewing, I don't know the exact number, but for quite a few years, because I still buy a clam license.
10 years, 15 years, 10, 5 years?
I'd say probably 10 years. But I buy a lot of licenses that I don't use just so, because I lost my, back when they did the license reduction on crabbing years ago, because I was conking in the ocean and not using it, without warning, I lost my crab pot license and my paler pot license. So I had to turn around when it was time for me to do those jobs again and buy them, and cost me, quite a few $1,000s. And anyway, it was my fault, it was just, I just forgot to do it, neglected to buy it, but wasn't intentional. But I just like to keep my right to, to go to work.
What's it cost to renew your license?
I think with the user's fee, is the user's fee around 300?
I think so.
And then the license itself is not that much. The user's fee, once you got that, you get the license for $50, I guess.
The user fee's fairly new. I mean, that, you didn't used to have to buy that every year. I think that came out in 08 or something like that. When was the user fee came out?
User fees were, replaced oyster taxes in 2013.
2013.
2016 was when the requirement to purchase every year began.
Yeah, so it's, fairly new. Before 2013, it was $10 or $10 to go hand tonguing.
Now, I only ask because I can understand with all the commercial licenses, user fees, et cetera, it can get kind of confusing to keep track of all of this stuff. I'm not a commercial waterman, I'm a commercial captain, but I get it. I understand what you're saying.
Any more questions for the speaker? Mr. Headley?
Mr. Eskridge, you don't have any violations for oystering?
No.
No.
No, I don't. And if y'all wanted to fine me for it, I mean, that's, I'd be willing to pay a fine. I just want to keep the right to, to work is all.
How do we go about if we want to make a?
Well, I would say if you want to make a motion, if you make it, I'll vet it through council, who's sitting here vividly waiting to hear what you have to say.
Being a commercial waterman and knowing where Mr. Eskridge is coming from, I have a fistful of licenses that I have to keep up with every year. And yes, it is my job to do it. But I can understand and see where one can fall through the cracks. And with no prior violations or anything, I would make a motion for Mr. Eskridge to get his oyster user fee reinstated.
Second.
And a motion and a second from Ms. Lusk. They're quick on that. Let me get a verification from council. Kelsey, is this proper? I know we've done it before, but I want to hear what you got to say before I move forward, because you're on the record, by the way.
We have done it before, and it's not a statute, so it is a commission regulation, and so they can give an exception.
Okay. Thank you for that. So we have a motion and a second. Please proceed.
Just for a quick clarification, in the past, sometimes there's been an exception, it would be paid this year's fee back in, or any fees that haven't been paid until then, so just want to clarify the commission as well on past fees there. So no
Paid
confusion.
fees. Mr. Erskine.
Mr. Button, can you explain what the user fee, was it the user fee, Mr. Eskridge, that you failed to pay?
User fee.
What that goes towards?
The commercial, the All Gear Oyster user fee helps provide support for the program, which helps run our program, including shell planting and replenishment of public ground. So it really supports the work that the commission does to maintain the oyster population and replace the oyster taxes that were levied on oyster harvest prior to 2013. So we replaced that to support the public fisheries.
Thank you.
Yeah, I would say that this, Mr. Eskridge, you know how important it is to buy your licenses. I just want to remind you how important it is for our replenishment program for you to buy this license.
Yeah. And just to let you, I'm not opposed to the user's fee at all.
So
I think it's going for a good cause.
And we don't like being put in these situations, but we totally get it. So, I have a motion and a second from Mrs. Lusk.
Mr. Button got up and said that, in the past, if we did,
Yeah, pay the previous fees.
you have to pay the previous fees. You okay with that, Mr. Eskridge?
I'm fine with it.
Is that perfectly legal, Kelsey, for him to pay last year's and this year's to get up to date?
I don't see why not.
There we go. All right, we have a motion to pay your fees up to date and a second from Ms. Lusk. Any further discussion? That being said, all those in favor say aye. Aye. All those opposed? Motion carries.
Thank you, appreciate it.
Thank you.
Buy or use a fee. I mean, I'm pretty sure being from Tangier, you know how important that is. All right, public comment. I have one more, I think, that wants to talk about licenses before I move forward to open the floor. Is there Mr. Smith here that wants to speak, or did he not make it yet? Come forward. Don't raise your hand. We're not going to yell across the room. Let's see what you got. If you're representing him or trying to, let's see what you got. Raise your right hand. You swear to tell the whole truth, nothing but truth, so help you God?
Yes, sir.
Please state your name for the record.
James E. Hudgens, Jr.
Okay. Proceed, Mr. Hudgens.
Mr. Smith is outside in the automobile. He took the wrong medications this morning, and he fell asleep coming over here, and I was a passenger in the car. So I got him immediately to pull over and got behind the wheel and proceeded to come down here.
Should we have him taken or to have emergency services respond since he's taken the wrong medication?
He took sleeping pill.
Well, that's still bad enough.
Well, I think he's okay, but.
Are you a doctor?
Sir?
Are you a doctor? Can you, law enforcement, Colonel Bell, check on this man?
That's the Buick?
He'll find
Okay.
it. Trust me. He's
in the parking lot.
he's very good at what he does.
Good.
So proceed. Now, so you're speaking on behalf of said individual?
I'm just letting you know that he's here, but he's incapacitated.
Well, I would say if he awakens and can make it in here, we'll speak. I'm not sure that you can represent him. Kelsey, he can't speak on his behalf, can he? I wouldn't think so.
Not knowing what the topic is or what his relationship is or whether, clearly this person hasn't authorized him. I understand this is an emergency situation, but I wouldn't be totally comfortable with that.
Absolutely, I agree. I know what the topic is, but I would say this, Kelsey, knowing his current state, I'm not sure he's competent enough to give authorization for somebody to speak for him at this point. So until I feel better that he's, aware and alert enough to make that conscious decision, I'm going to say he's going to have to come back to another public comment. I'm sorry.
Well, that's what I was trying to ask you, if you could just pass it, but, give him another chance to.
Oh, he'd come public comment anytime.
Yes, sir.
No worries. But thank you.
Thank you,
for your time.
Commissioner.
All right. That public comment is open for the floor. I think that's the two licensees. Is there anyone here that would like to speak during the public comment period now? Please proceed. Please proceed. How are you doing?
Locked up.
That's okay. Please raise your right hand. You swear to tell the whole truth, nothing but the truth, so help you God?
Yes, I do.
Please state your name for the record, ma'am.
My name is Julie Kasmarsik. I have just two simple questions to start out for the board. If you could answer with a show of hands. Do you all call Virginia home? If you do, please raise your hand.
We're not taking a survey. Kelsey, you want to comment on this?
It's just two generic questions.
Usually we don't have speakers ask the commission questions. It's usually the commission's job to ask the speaker questions.
Okay.
For the record, Commissioner, we all have to be Virginia residents to be appointed by the governor.
Correct.
Oh, thank you, Mr. Bransom. The second question that I won't ask was, do you care about Virginia? So just stay with me and try to think out of the box a little bit. Help me understand this scenario. Just fictitiously pretend Mr. and Mrs. Erskine live in Gloucester, They live by the bay. They have 3 children, one named Striper, one named Osprey, one named Gannet. They buy their food from the Chesapeake Bay. Sadly, little Striper, Osprey, and Gannet are starving because their favorite food and their dietary requirement is no longer there. That favorite food and their dietary requirement is menhaden. Where is the menhaden? It was taken by another store. Where's the store? The store is not in this country. The country is Canada. The food that feeds the mouths of the wildlife in the Chesapeake Bay, the biggest estuary in this country, the United States of America, this food is being sent to Canada. Why would you, and just take it as a rhetorical question, why would you, as residents and lovers of Virginia, take food away and out of the mouths of the babes in your home state? It's a simple question, and it has a simple answer. And I notice there's not a lot of eye contact, and I will just take that as I see it. I leave you with this quote from Albert Einstein: "The world will not be destroyed by those who do evil, but by those who watch them without doing anything. You are the change makers. You have the ability. Please use it wisely." Thank you.
Any questions for the speaker? From the commission? Thank you, Bill. Thank you.
Thank you.
Anyone else would like to speak during the public comment period? You swear to tell the whole truth, nothing but truth, so help you God?
I do.
Please state your name. For the
My name's Andy Cortez. I have a document I'd like to give to Mrs. Lusk. She was not in attendance when I spoke last time. It was.
Mr. Dameron, can you come get that, please?
Thank you. I was hoping that Mrs. Kellum would be here today and Mrs. Edwards. My comments today are directed to Mrs. Kellum regarding the last meeting of October 24th. So in some ways, I'm going to be preaching to the choir today. I hope you'll bear with me. I don't believe you. Well, let me just continue. On October 24th, Mrs. Kellum used a loophole to circumvent the Conflict of Interest Act. She voted on a matter in which she had a personal interest. Now, what she did was ethically wrong, even though it was legally right. Aldo Leopold, one of the great conservationists of the 20th century, said, "Ethical behavior is doing the right thing, even when doing the wrong thing is legal." So while disclosure of her situation and the vote that she took may have protected her company and benefited her client and insulated her from criminal prosecution, it still didn't change the facts. You see, she has a fiduciary duty to do no harm to her company, Ampro. At the same time, she has a sworn duty to serve the Commonwealth objectively and without any bias. So when you have a personal interest, these duties conflict. Her promise to remain unbiased, while well-intended, is subjective and unverifiable. Only God can see in our hearts. The credible way for her to maintain objectivity would have been to abstain from the vote if there was any potential conflict of interest. So moving forward, I ask that this board will do the right thing, even when doing the wrong thing is legal. Any questions?
Any questions for Mr. Cortez? Thank you, sir. Thank you for your time.
Thank you.
Anyone else wish to speak during public comment? Please come forward. Raise your right hand. You swear to tell the whole truth, nothing but the truth, so help you God?
Yes, I do.
Please state your name for the record, the microphone.
Roberta Kellum. Good afternoon, Commissioner Green and members of the commission. My name is Roberta Kellum, and I live in Franktown in Northampton County on the Eastern Shore. I am a former two-term member of the State Water Control Board. I served under 3 governors for a total of 9 years. What I have done is actually written a letter that's probably too long for me to read and present. So if I'd like to have it distributed, and I'll just give you a brief synopsis of my letter. As I stated, I was on the State Water Control Board, and our board oversaw the Chesapeake Bay water quality issues, including implementation of the Chesapeake Bay TMDL, adoption of water quality and wetland regulations, distribution of state funds for water quality improvement projects, and enforcement of violations of the state water quality laws and regulations. Over the past few decades, hundreds of millions of dollars have been invested into restoring the water quality of the Chesapeake Bay. This includes taxpayer funds from federal and state governments, private investments necessary for compliance, and nonprofit investments into conservation projects. In exchange for these investments, the people of Virginia are promised fishable and swimmable waters pursuant to the Clean Water Act. Much progress has been made in restoring the biological, chemical, and physical integrity of the Chesapeake Bay, yet these achievements will mean nothing if the keystone marine species, such as menhaden, are depleted from the bay. The State Water Control Board and the citizens of Virginia have done their part to ensure that the Chesapeake Bay is a fishable water. I am here to ask VMRC to do its part to protect the fishery resources for the benefit of all the citizens and the wildlife of the Bay watershed. It is abundantly obvious that the industrial menhaden reduction fishery operated solely by Omega Protein in Reedville, Virginia, the only industrial menhaden reduction fishery in the Chesapeake Bay, is drastically depleting the available food supply for economically important species such as striped bass, as well as ecologically important species such as osprey. This fishing has been allowed even though there is little study about the menhaden population and little study about the impacts from global warming on all of the fisheries. I know that you have heard about the imminent extirpation of breeding osprey from the western shore of the lower Chesapeake by Dr. Brian Watts from the College of William and Mary. He has, and that department has studied the osprey for about 50 years. They're very familiar with what the osprey eat.
Ma'am, can you wrap it up? You're out of time.
I'm sorry.
Please close it.
Gee, I thought it was going to be 3 minutes. I guess I was.
That was 3 minutes.
That was okay. What I'm asking today is that the VMRC take action and declare a moratorium on the menhaden fishing for 2024 from the spring to the midsummer when the osprey are breeding, to give the opportunity for the osprey population to have a rebound and have a successful breeding season this year.
Thank you.
Thank you.
Any questions?
It's
Wait a minute.
okay.
Wait.
It's okay.
There's no yelling across this commission room.
It's okay. You can come up and ask for the same thing.
Thank you very much for your time. Anyone else wishes to speak? Please proceed. You've been sworn in. Just state your name for the record, please.
All right, thank you. My name's Tom Burkett. I live in Eastville, Virginia, in Northampton County on the eastern shore of Virginia. My request for you today is to initiate a moratorium on Omega Protein's menhaden reduction fishery for the year of 2024 and in continuation until the Commission can review Virginia Institute of Marine Sciences Atlantic Menhaden Report for the Chesapeake Bay as directed by the Virginia State Senate. The Virginia General Assembly passed legislation during the 2023 session that directed VIMS to develop a plan for studying Atlantic menhaden in the waters of the Commonwealth. On October 1st of this year, VIMS produced the Atlantic Menhaden Resource Planning Report and determined research priorities. The report determined that the VMRC does not have a stock assessment of Atlantic menhaden in the Chesapeake Bay. The VMRC does not know the seasonal abundance of menhaden in the Chesapeake Bay. And the VMRC does not know the severity of the localized depletion of Atlantic menhaden caused by omega proteins industrial fishing techniques, or how long it may take the Chesapeake Bay ecosystem to recover from an excessive depletion of biomass, and whether recovery will even be possible. Here's what the VMRC does know. The Commission knows that VIMS published record low striped bass recruitment numbers in the Chesapeake Bay for 2023. This is the 5th consecutive year of juvenile striped bass numbers being below average. The Commission knows the College of William and Mary published record low osprey chick recruitment numbers in the Chesapeake Bay for 2023 as a result of food scarcity. This marks the lowest reproduction numbers of osprey since 1970. The Commission knows that in 2022, VIMS published record low Chesapeake Bay blue crab abundance reports, the lowest in the 33 years of research history since 1989. And the Commission knows that all other states in the Atlantic coast have removed industrial menhaden fishing from their bays and state waters, and have now recorded positive ecological and economic responses in doing so. VIMS has laid out methodologies in which they will be able to determine both spatial stock assessment of menhaden, the seasonal stock assessment of menhaden, and the state of localized depletion due to omega proteins industrial reduction fishing techniques in the Chesapeake Bay. The timeline for this research is estimated to be completed in 3 years. So the science is saying 3 years, and in 3 years, the Commission will have a comprehensive report. If the Commission continues to allow omega industry to operate menhaden reduction fishery in the waters of the Commonwealth without knowing these components of the fishery, while scientists are recording record low reproduction assessments for multiple predator species in the Chesapeake Bay, it would be a mismanagement of state resources and neglect your state governance responsibilities. Therefore, I urge you to use your authority to initiate a moratorium on omega proteins menhaden reduction fishery for the year of 2024, and in continuation until this Commission can review the VIMS menhaden report for the Chesapeake Bay as directed by the Virginia State Senate. Thank you for your services, Commissioners.
Is there any questions for the Speaker, please? Thank you. Thank you.
Thank you.
Anyone else wish to speak during public comment? Please come forward.
My name is Frances Lynn Jenkins.
You swear to tell the whole truth and nothing but the truth, so help you God?
Yes, sir.
Welcome, Mr. Nancy.
Thank you for your time today, Commissioners. And on a personal
Please
note.
talk to the microphone so they get
Okay,
it for record.
sorry. Hope you all had a wonderful Thanksgiving. My comments today are, once again, just like the speakers before me, concern over the menhaden fishing in the industrial levels, especially the lower Chesapeake Bay. There have been documentaries on this. I'm sure you all are aware of that, and what I'm just here to do is to make sure you're aware of that. The brand new documentary called The Biggest Little Fish You've Never Seen by Bill McGeever was just released in August. I urge you all to please watch that documentary if you have not already. And then I just recently became aware of the documentary that was produced 11 years ago called Menhaden, the Most Important Fish in the Bay. And recently watched that myself and was especially concerned over 2 points. That documentary, 11 years ago, talked about the menhaden only being at 10% of their original numbers. And that was 11 years ago. And yet, you all continue to let omega protein do industrial commercial fishing. And I do not understand that. And the very breakdown of the ecosystem that they predicted in that documentary is what is beginning to occur. So please pay attention. Thank you.
Any questions for the speaker? Thank you. Is there anyone else that wishes to speak during public comment? Please come forward. You swear to tell the whole truth, nothing but the truth, so help you God?
I do.
Please state your name for the record. and the microphone.
My name's David Farber. I'm from Oyster, Virginia in Northampton County. I'm going to read a short statement here. I've addressed it to Mr. Green and commissioners. I write to express my concern for the commercial harvesting of the menhaden stock in the Chesapeake Bay. My fear is that the process that is currently being used is not only depleting the target fish at a rate that is not sustainable, but also for the collateral damage that the current practice is incurring on other species of fish, and also the damage it is doing to the habitat, which is vital to the existence of other aquatic life. My knowledge on the subject is, for the most part, anecdotal. I'm the owner and operator of a charter vessel out of Cape Charles Harbor and have fished the lower bay for 50 years. I've noticed a steady and increasingly rapid decline of bluefish, gray trout, and striped bass over the past 25 years. I believe it is in large part due to the overharvesting of menhaden and the use of improper equipment that is used in the water that is shallower than the nets are designed for. My most requested charter is the sunset cruise from Cape Charles to Kips Peak State Park to see the concrete ships. The trip takes 2 hours, and along the way we pass no less than 3 osprey nests. For the past 2 years, there have been no chicks in the nest. It is my understanding that this could be due to the lack of food available. If food is scarce, both adults must hunt to stay alive, leaving the nest unguarded and the eggs and chicks vulnerable to predators. We seem to be at a crisis, and if action is not taken, we may be jeopardizing the existence of a wide range of aquatic species that so many of us depend on for many reasons. Our natural habitats are under siege from many fronts. This is one assault that we have the power to control. I urge you as a commission that has the power to ease the pressure of overfishing and reckless use of improper equipment to use your authority to move the menhaden fleet out of the bay and into the deeper waters of the Atlantic where their equipment can be properly set. Maryland and Delaware have already done so. Let's not wait till it's too late. Thank you.
For the speaker. Thank you, sir.
Thank you.
Anyone else wish to speak during public comment?
I can go twice. You'll let me go twice, sir, won't you?
No. Give me a second here. You want to pull your time, is that it?
No,
You're not going twice, then sit down.
I can't go twice.
No, sir, you don't.
It's
Have
a
a
different topic.
seat. You can talk on another time. You use your 3 minutes of public comment. Is anyone else want to
But
speak?
that was on a different topic.
Public comment.
I
Have a
talked
seat,
on
sir.
ethics.
Have a seat.
I talked on ethics, and this is about something else. This is about the menhaden.
Officers? Anyone else have a topic that want to present? Come here, please, come up, buddy. Escort him out, please.
Escorted out?
Escort him out. Raise your right hand. You swear to tell the whole truth, nothing but the truth, so help you God?
I do.
Please state your name for the record, ma'am.
Christy Meadows from Silver Beach, Virginia. And thank each and every one of you for your time and effort on this. I really do appreciate that. And you heard about a film that was done by Bill William McKeever. And I'm offering a chance to show that film. I will gladly, anytime you all would like to see it, I will gladly come to you, show it to you, and wanted you to know that. And I can leave cards with my number if you want to call me. I'll gladly leave you cards if you don't mind picking them up, sir. But also, not because of time, but I also wanted to say that, yeah, the nets of the menhaden boats are still too big for the bay. We know that, and they promised that they were going to go to 30-foot nets, but that hasn't happened to my knowledge yet. And they have to get shallower nets because they're still having problems out at the bridge tunnel. They're still having net tears at the first island coming across the bay, coming over here. They're still having problems because the nets are too big. And they've got too much stuff going on in those nets, and I just wanted to just reiterate that. And I'm going to stop it right there. And I will wish each and every one of you a Merry Christmas, and I hope you have a great holiday season. And thank you so much for everything.
And Pat, can you get a card from her, please? Thank you so much.
Just to add into that, we do have a copy of that film, so if anybody wants to see it.
I was held hostage by Jim Rogers and had to watch it.
Did he hurt you?
No, trust me, I'm okay. Any questions for the speaker? Thank you so much. Pat, can you come to the podium for a second? Are you aware of, can you come to the podium for a second, please? Are you aware of any spills this year?
No, sir, we have not had any reported spills from Omega or any other companies. We do occasionally get calls that there is fish out there, but we had no documented spills this year.
Law enforcement, Colonel Bell, you got any complaints on any spills from Omega?
Not from Omega.
Thank you. Anyone else wish to speak during public comment? Thank you. Next item on the agenda, Alicia. That's okay.
I just have a comment.
Go ahead.
Sitting here, I can't help but notice that there are no less than 4 speakers here from the Eastern Shore that are concerned with the environmental impacts of the Menhaden fishery. And I just wanted to comment that I think, you know, we talk a lot about the economical importance to the Menhaden fishery in the Deltaville area. But, you know, on the Eastern Shore, we have agriculture, aquaculture, and tourism. And that tourism is driven largely by its environmental tourism, birding, fishing. And so it is alarming to hear that of a decrease in the osprey population. I'm not sure if you're aware, there's a large birding festival that's held on the Eastern Shore every year. It draws a number of tourists at a time when tourism is otherwise slow. And that's very important to the economy there, as well as recreational and commercial fishing. And so I just want to thank all of these people from the Eastern Shore and otherwise for coming out and speaking. And I think that this is, it's a big issue to grapple with, but it's very important that we do, because there are other communities and other economies that have maybe a different perspective. And I think I really appreciate these people coming out and speaking, and I think that as a commission, it's important that we really listen to them and take that into consideration.
I appreciate that comment. I can assure you this commission listens, especially this commissioner, to everyone, first and foremost. Secondly, we've partnered with VIMS. Been great to us. We've worked with Dr. Watts, I know Dr. Lukenbach has. We are interested in trying to help secure the funding to see what this is, to see if correlation and cause and effect are lining up. That's what we're trying to do here. And we don't take for granted any portion of the Commonwealth or anybody's interest, whether it is bird watching, tourism, or economic value in the Northern Neck. So I do understand it, and we're trying to make sure we move forward. I think we do have a good plan. I think Dr. Lukenbach did a 2 or 3 day study. We've talked about it, and it has a lot of Dr. Watts' stuff, and Dr. Watts is involved. So we're trying to move forward and hopefully get this information that we need to be able to make sure we're making adequate, educated decisions on this matter and not just missing something else. So, but yes, I agree with you 100%. Thank you. Alicia, are you ready?
Good afternoon. All right, good afternoon. These are the recommendations from both our recreational and commercial fisheries advisory boards. Our Recreational Fishing Advisory Board advises the Commission on expenditures from our Recreational License Fund. That's the Virginia Saltwater Recreational Fishing Development Fund. This year, throughout their cycle, they reviewed 12 projects. They finished that cycle in September with their voting meeting. Our Commercial Fishing Advisory Board advises the Commission on expenditures from our commercial fund, which is titled the Marine Fishing Improvement Fund, and they reviewed 3 ongoing projects and a new program that I'll describe in November. Please note that 2 of those projects are traditionally split funded by both of those funds because they benefit both recreational and commercial fisheries, but each was reviewed separately by those separate advisory boards and voted on. I'll start with the Rec Board. They reviewed 12 projects this cycle and recommended funding 11 of them. I'll list them below. And the total is under $300,000 from that license fund. Starting with our fishing event applications for 2024, there are 6 listed here. The total is just under $30,000. However, many of these groups have been working with us for some time, have expanded into multiple events per application, so there's at least 10 that are planned for 2024. So with this list, it's actually an awful lot of children's programs. There are some programs for a few nursing homes and one for adults with disabilities. So it does reach a lot of folks. Our other programs are listed here, and this slide does include those 2 that are split funded, items H and I. Our tagging program, our Young of Year American Eel, which is funded by both funds, the match requested from our federal funds, I know you've heard me discuss many times, and our Sportfish Collection Project, which we also refer to around here as the freezer program that's done in-house. We had 2 new programs come before this board this year. Item K was not recommended for funding based on some concerns with how to contract that and some other discussions with that application. Item L was recommended to fund, and that is a project out of Matthews County where they're going to be doing a little bit of modifications to the pier railing and the boardwalk associated, but also that includes an educational program, which includes sort of a donor program for fishing tackle. That's something new for us, and we're trying it out this year. On the commercial board, our Commercial Fishing Advisory Board reviewed and recommended funding for all the projects that were heard this year. 2 of them were listed on the previous slide, was the eel survey and our match funding. The other 2 is one you may have heard me speak on before. That's our monitoring of river herring in Virginia. These are additional project funds, so this is part of a larger project really for that sport fish restoration match that has been traditionally a shad project. A number of years ago, we realized we could add funding and also cover river herring with sort of the same group of scientists with that add-on money. So with this, we're able to cover 2 different species using the same larger project. And the CFAB voted unanimously to fund that project. The last one is the spiny dogfish industry economic support, and I have a few slides on that because that is a little bit different. That is an RFP approach, and I'll explain that. So earlier this spring, the primary buyer in Virginia for spiny dogfish shut down. Most of that industry lands in the Rudy Inlet area and won't have a buyer for the upcoming season. They reached out to VMRC requesting assistance for that purchasing and moving that product north. Staff proposed using that Marine Fishing Improvement Fund to support proposals from individuals to purchase and ship that to that remaining processing plant on the East Coast, which is in Massachusetts. The way we would do that if approved by commission is to initiate an RFP process or request for proposals, and that would be initiated soon after this meeting where we would put that out and accept proposals to purchase and ship that product in this upcoming season. So our goal there would be to award that contract early in 2024 so that there would be some assistance and someone to buy that product for the rest of that season. They did vote unanimously in support of that approach. After that, staff reviewed sort of the concepts and ideas with industry members and came up with a budget of up to $150,000 to support those proposals. And the last slide, if anybody has any questions, I'm happy to flip back. The last slide is just sort of the totals from each fund. $289,000, $154,000 from the Virginia Saltwater Recreational Fishing Development Fund, and $227,541 from the Marine Fishing Fund, Improvement Fund. Any questions?
Any questions for Alicia? Mr. Headley?
The spiny dogfish, the $150,000 for that, considering they have a buyer that is currently operating right now, what would that go to or towards?
So how that works, because it's an RFP process, we needed some sort of budget. So the $150,000 is our budget, and it's a range. So what would happen next if approved is that we'd put out an RFP. That doesn't give a specific budget. That would be us accepting proposals from other entities, and our top would be $150,000. So it could be less. It could be several, and those proposals would be for the services of purchasing and moving the product. Does that make sense? So as far as the details of the budget, those are the proposals we'd be collecting next to see what that would go towards. So a proposal could come in and say, here's how we suggest using those funds in order to provide that service for this spring. So what we're actually purchasing is the service, if that makes sense.
Any more questions for Alicia? Well, that being said, any comments from the public on this? All right, matters before the commission.
Motion to approve staff recommendation.
Motion from Mr. Erskine to approve staff recommendation. Do I have a second? Second.
Second.
Got a second from Ms. Lusk. Any further discussion? Matters before the commission. All those in favor of accepting staff recommendations, say aye. Aye. All those opposed? Motion carries. Thank you. All right, that looks like we got that. Is that it, Alicia? Were you last? Oh, wow. That's good. All right, that being said, thank you all for coming today. There being no further business, this meeting is adjourned. The next commission meeting will be Tuesday, January 23rd, 2024. Wow, 2024. Whoa.
That's a great, good job on shoreline. That was a really good observation on your part. I thought that was very, well, that's your background as a contractor.
I was impressed by your presentation, just in general.